set to begin. Just make sure everybody's mics are on and they're all set to go.
Permanently on for this, I guess. Yeah.
Okay, good afternoon, everyone. Let me start by making the initial announcement. In accordance with MGL Chapter 30A, Section 20, I must inquire whether anyone is recording this meeting, and if so, please make their presence known. If not, I will turn it over to Cynthia to do a roll call.
Members of the committee. Mr. Schulte in chair.
Here.
Ken Alsman.
Here.
Catherine Leduc.
Here.
Councilor Jeffrey Mendez.
Here.
Councilor John Crow.
Here.
Councilor Matthew Levesque. Councilor Kristen Turkelson. Councilor Charlie Bloom.
Here.
You have quorum.
Thank you. I'll just mention that Councilor Turkelson said she may be a few minutes late. She's coming from work. And it was just pointed out to me that I forgot to mention, as this is my first meeting here, this is a meeting of the Committee to Review and Assess Zoning and Review the Town's Use of Regulatory Agreements. Before we get started, I'd like to say good afternoon to everyone here today, as well as to any members of the public. Here's Councilor Turkelson. Or anyone else participating remotely. Thank you all for attending and for your interest in the work of this committee. I believe I speak for all the committee members when I say that we want this committee to be an opportunity for any and all residents and interested parties to provide input on their concerns, issues, and thoughts regarding the town's zoning and use of regulatory agreements. We encourage and welcome that input. As the chair, I view this committee as a working group which will gather and discuss all relevant information to the aspects of zoning and regulatory agreements discussed by this committee and will ultimately make recommendations on these topics for consideration by the town council. My strong preference for the format of these meetings would be to hold them in a less formal, more collegial environment, such as tables at which we could all sit together and facilitate the easier exchange of and discussion of materials and ideas, versus being spread out like this from one side of the room to the other. I had a nice conversation with Sarah Beal about the format, and she explained to me the limitations with which she and her team are working, and unfortunately, the difficulty and time needed to set up the room for audio and video to accommodate a less formal environment preclude us from doing so at this time. However, Sarah did tell me there is a possibility, remote perhaps, that technological improvements will be made to the Selectmen's conference room in time for us to make some of our meetings happen in a more informal setting, and I'm hoping that's the case. Next, I have just a few housekeeping items. I don't see Attorney Connolly in the room, but first we wanted to acknowledge that we need and are waiting for the appointment of a fourth member of the public to the committee to replace a member who had to resign because of their availability to attend meetings. The Appointments Committee has agreed to put this matter on the agenda for its July 24th meeting, and we hope to have a new member of the public appointed to the committee very soon, so we'll have a full 9 members. The second item has to do with the dissemination of the minutes of our meetings to anyone outside of the committee prior to them being reviewed, comments received by Cynthia, and formally approved by the committee. I'd asked Attorney Connolly to advise us on that matter, and as she's not here, I'll just mention her discussion was that prior to the approval of the minutes of our meetings, they are not to be discussed or disseminated or provided to anybody outside of the committee. So I ask that all the members of the committee respect that. Third, a member of the public suggested that all the information and presentations that we receive and consider be organized and placed on Laserfiche so the public can access it. I think that's a good idea, and I'd like to thank him for that suggestion. I'll ask Cynthia if she might be able to look into the possibility of doing this with IT. I know that we don't have a subpage set up on the town website, but to see if maybe we could either have a subpage set up or have somewhere that we can have access, the public can have access to the meeting, the material, the minutes and materials that we discuss in the meeting. As stated on the agenda, for today's meeting, we will be holding a redo of the portion of the June 28th meeting, following the election of the committee chair. As many of you know, the reason for doing this is because we were Zoom bombed several times during that meeting. Cynthia did everything she could to control the problem, but was ultimately forced to shut down the Zoom recording. Attorney Connolly and I have spoken several times, and she's confirmed that the June 28th meeting was a valid meeting, and the election of the committee chair was held appropriately, and there will be no need to do a revote for the committee chair. Before I turn it over to Cynthia to provide us with a brief summary of the discussion held by the committee, I'd like to mention one of the letters we received from the public suggested that each of the members of the committee introduce themselves and what they bring to the table. We actually did that at the June 28th meeting, but since it wasn't captured on video, I'd like to do that again for the benefit of the public. So if we could, I'll start to my left with Councilor Turkelson.
Councilor Turkelson, I bring a beginner's eye.
Councilor Mendes, lifelong Cape resident. My family's been here for generations, so I think I bring not only tradition, but a forward-looking outlook as far as the needs and wants of the town.
Councilor John Crow. I come from the Austinville Village Association for about 24 years there, and I'm also a newbie on the zoning and regulatory, and looking forward to learning as much as I can in a short period of time.
Good afternoon. I'm Kathy Ledeck. I live in Barnstable Village, and I'm one of the resident representatives on the committee. I bring more than 25 years of experience working with zoning regulations and the implementation of those in Fairfax County, Virginia. I moved back here to Massachusetts after growing up here as a kid. And my husband and I live in Barnstable Village. I've done a lot of work on environmental protection and on land use and matters such as what we're going to be talking about here in the committee. I look forward to helping us get to a good solution here. Thanks.
Whoops. Got to learn how to use this.
All right, go ahead, Ken.
Ken Alsman, I live in Katuitt. My background is in city planning and economic development back in California in the town of Mountain View, where I spent over 20 years. And I guess that's what I bring to the table, a background in planning and economic development.
Charlie Bloom, Precinct 9 counselor. I don't bring anything to the table like Ken brings. I'm here to learn.
So, here we go. Felicia Penn, ad hoc member of this committee. I'm the chair of the town council as of this time. I have no vote on this committee, just to remind everybody. My interest has always been in planning and development. When I was a little kid, my mother keeps reminding me, I remember Matchbox series cars. You remember those things? I used to spend my allowance money on that, or my work money on those. And I used to go out in the yard and create villages. And I named all the cars different names, and each one had their own character and whatever, and I'd create different villages, and I'd destroy them when they weren't any good, and I'd start all over again. And she constantly used to remind me of that and told me when I started to play music and become a music major, she said, "Don't you want to go into urban planning?" I said, "Oh, yeah, Ma." So anyway, I did spend 9 years on the planning board, and I'm always interested in economic development that represents the best of a community. That doesn't mean the most people with money. It means that it enhances the best values to the people who live there. And I know Charlie went to school here. I went to school here. Jeffrey did too sometimes. I'm kidding. Anyway, so look forward to this committee. There's a lot of stuff that's happened here, and we have some good staff here today in an actual chair of the planning board here also. So hope we have some good discussions going forward. Thank you.
And I'm Bob Schulte, the chair of the committee, 30-year resident of Centerville. I was one of those people who made the daily commute to Boston for over 25 years, but my heart has been in Barnstable. I was a partner in an international consulting firm for 30 years, dealing with various financial and complex business arrangements. I've been involved with numerous civic and nonprofit activities and organizations throughout the town. Have been a regular at town council meetings and various committee meetings for years, which a lot of people have seen me at, and very interested in these topics. So that's why I was interested in applying and participating in this. So I think hopefully that's a sense for who all the committee members are. With that, I'll say it's time for Cynthia to provide us with a summary. I'll mention while all the committee members were present at the meeting and have had an opportunity to review and comment on the draft minutes of the meeting, I've asked Cynthia to pause after each major topic included in her summary in case any of the committee members wish to make any additional comment. For any members of the public, I ask you to please hold your comments until the public comment section noted on the agenda, which will be coming up shortly. Cynthia?
Right after we were Zoom bombed, that's correct, I shut down the link, and the discussion continued for public comment. The chair asked for public comment. Eric Schwab had issues with commercial use in residential areas and hopes that the committee will look at the inner neighborhoods as well, where a lot of this takes place. He also hopes that the public comments and correspondence will be looked at from residents that have similar problems and issues. Councilor Bloom asked him about a map he had created to pinpoint in the town where most of these issues were occurring. He reported that Hyannis obviously had the most issues because it's the most populated. West Barnstable had the least, and he believed it was due to the density. Councilor Crowe asked what was the most driven complaint. And Mr. Schwab mentioned overcrowding of cars in residential areas, basement apartments, auto body repairs, and pouring hazardous waste down storm drains. There was discussion following parking, single-family homes, and the chair of the committee at that time mentioned the local comprehensive planning committee that's also looking at zoning and short-term rentals. And zoning seems to be the biggest issue in the town, as mentioned in emails and most of the public comment that we received. Next, the chair of the committee handed out this draft document. This was put together by the town council leadership, and it had some good talking points that we're going to be discussing. So that document was passed out. Ms. Ledeck commented that there were boards, committees, and commissions that deal with zoning daily, and some of those sections could be tightened up to help the enforcement of them. She would like to hear from those committees on the issues and typically that they face at their meetings. Town Councilor Turkelson met with Brian Florence and recommended we have Brian come explain the enforcement to the committee so we have an understanding how enforcement works. Councilor Mendez mentioned we need to be careful on limiting the number of cars at residential homes. He cited a case that went before a judge that the neighbor actually won and not the town. Attorney Connolly then mentioned that the town could put in a bylaw regarding the number of cars allowed if they choose to. Mr. Alsman mentioned he struggled to understand regulatory agreements, which is why we have Mr. Kuffner here tonight. President Penn gave a brief explanation how the regulatory agreements happened in 2006. They're agreements that are waivers outside of zoning regulations and only pertain to the growth incentive zone, not the entire town. Then Mr. Kuffner was asked how many there are currently. There's 23, but mentioned very few are asked for currently. And most of these projects go before the planning board, and if the planning board recommends them, they go to the full council for approval. If the planning board does not approve, it never reaches the council for a vote. And then the committee went on to discuss the next members that they were, or individuals I'd like to invite to today's meeting and to plan their next meeting.
Thank you, Cynthia. I'll ask if any of the committee members have any additional comments at this point. No? Thank you. I think the next thing we'll do, and we'll probably do this at the beginning of every meeting, just to restate the purpose of this committee, which is to work with the town's planning and development staff to review and reassess recently adopted zoning changes, review the town's use of regulatory agreements, and make recommendations to the council. The next item on the agenda is item B, committee members to review correspondence sent in from the public. To date, we've received several emails, letters from the public. Copies have been provided to all the committee members for their review and consideration. As I think is the practice at most of the town council and committee meetings, in the interest of time, we will not read each letter aloud, but I'd like to acknowledge our receipt of emails and letters from the following individuals: Tim O'Neill, Ann Salas, Steve Robichaud, and Eric Schwab. I'll ask if any of the committee members would like to address any specific comments in the letters we received to date. And I'd like to thank the members of the public for sending those comments in to let them know that we've received them and considered them by the committee. So I'll ask if any of the committee members have any specific comments they'd like to make about the letters we received to date.
I'd just like to take the opportunity to thank the members of the public who are here today and those who are listening online. I'm very interested in hearing not just from residents, but also from businesses and other organizations in the town that have had experiences, positive or negative, working with the regulatory agreements and/or recent changes to the zoning ordinance. I'm very interested in hearing from the public. We can, sit here on our table and discuss what we think the problems are, but the most important thing for us is to hear from the public, especially those who have had experiences working with the zoning ordinance and/or the regulatory agreements. So I look forward to hearing from all of you, and please be as specific and as open as you can be in your comments. We would welcome that. Thank you.
Any other comments? Attorney Connolly?
Mr. Chairman, Kate Connolly, Assistant Town Attorney. You haven't voted the minutes yet, which is fine, because I'm just looking at them, and I just wanted to correct one thing, which Cindy did capture. I had been asked to comment on the discussion that Councilor Turkelson had with Brian Florence, Building Commissioner, and I did say something about, it wasn't so much parking, my comment, and I can give you the language for this paragraph. My comment was that municipalities can have more stringent local ordinances, and I gave as an example of one, because I thought it was kind of funny, that I saw out in some towns in Western Mass where they have a local bylaw that says no more than one disassembled unregistered vehicle per front yard is allowed. And I just thought, why would anybody want to have disassembled unregistered vehicles? But that was a very local bylaw that courts have upheld. And so you can be more stringent. You just can't be less stringent or inconsistent with the state. So I'll give Cindy some language, but I just wanted to correct that because I wasn't really talking about Barnstable needing parking ordinances or anything like that. Okay.
Thank you. While you're there, you weren't in the room yet. One of the items we covered during the housekeeping was dissemination of the minutes prior to them being approved. You and I had a conversation. I made a comment, but I'd rather it come from you as the attorney. The appropriateness of those being distributed to anyone other than committee members prior to the review and approval by the committee members.
Yeah, minutes should not be distributed outside of the committee. When they're in draft form, they should be just amongst the committee so people can make corrections on them. And then you vote to approve them, and then they can be released. That's how it should happen.
Great. Thank you very much. All right. I think we're ready to move to item C, which would be public comment.
Hi, this is on? Okay. Natalie Pittenger, Hyannis. I had received the output of a database that apparently the people that work for Brian Florence enter into when they have an incident that requires action on their part, and also for the health people. And anyway, long story short, I kind of massaged some of the data. I didn't think it was really usable the way we received it, so I did kind of jumble it around a little bit so that you can sort it by address, and you can see where certain addresses show up repeatedly for repeat violations. But I will say that there is a wealth of knowledge in this database if the information is massaged and looked at seriously. You can search on keywords and so on and so forth. The one thing that I found it was missing was solutions. They do say whether it's still active or if it's resolved. And they also give a priority to it, too, I guess. But they might say it's resolved, but they don't say what it took to resolve it. I think that that's where the key is to learn from this as to what regulations need to be enhanced to make this a shorter list. Okay? I think when I massaged it, I came out with, this doesn't show it, yeah, almost 200 pages. And so that's individual, that covers, I think, 21, 22, 23, and half April of 24. But anyway, recently there was this fire over on Oakland Road, I think it is. And at first, that's the first thing I did, was I went to the data list to see if Oakland Road was in here. And indeed it was. That particular address was not. So that's good, and I think they've since found there was another reason for the fire. But that's the kind of thing that I'm thinking can be prevented. I mean, that could have just as easily been perhaps a dwelling that had been enhanced with no permits. It's just all over this database, no permits. And it doesn't say whether they went back and they got the permits, or they did or they didn't, or what. You just don't know. And you should be able to know. So I think that they should be expanded a little bit in the way they enter their information to include how the permits came about, and if they did, and if the construction or the changes continued or not. Maybe they just stopped. But anyway, I think it's a wealth of knowledge, and I wish you folks would take a look at it, and maybe it would help you come up with some enforceable regulations. That's another thing. I guess I understand that Brian Florence has a hard time enforcing some of these things, and I can see why when I look at the volume. But they should be enforceable. I mean, if you're not going to enforce them, I don't know why have them, because people know you're not going to pay any attention, and so they're going to keep doing it. So I do hope that you come up with something enforceable and take a look at what prevails for the large majority of these complaints, and maybe try to do something to reduce them and fix them once and for all so they don't repeat. Okay, so that's it.
Thank you, Ms. Bittinger. Would you be willing to share that database? You've already done some manipulations of that? Is that
Yes,
something you
yeah,
can
I
share?
have one. I did them by community, or by village, I should say. So I do have one for Hyannis, and I think I did Marston's Mills, Centerville, and probably Osterville.
Okay. If it's
Okay.
possible, maybe you can provide those to Cynthia so she can distribute them to the committee
Okay.
members.
All right. I think I have your email, Cynthia, so I can send them to you. Okay, all right, great, I'll do that.
Great, thank you
Okay,
very
great.
much. Appreciate
Thank
it.
you. Yep.
And I was going to mention, I know typically there's a 3-minute limit. We have a fairly small group. I'm not going to worry so much about that, but I do ask people to be respectful of the time, so thank you.
Absolutely. Hello, good afternoon. Steve Robichaud from Barnstable Village. Just one small item I wanted to ask about, and that's just document storage, kind of a library for all the documents related to this subcommittee. Some boards and committees, I think, do a really good job of this in the town. Others maybe not so much. Town council, I think, does a great job of document storage. Everything's kind of a one-stop shop right on the town council website. Planning board, thanks to Jim, also does a very good job of this. So I just want to check on, for the public, it'd be great if correspondence. Something was mentioned about a document from leadership, kind of a summary and overview. I might have just missed that, but I haven't seen that. I'd love to see it, and I know the public would too. So if there's a way, maybe using the Laserfiche or something like that for a one-stop shop, I know you're probably going to generate some information, some documents. You may, reference some. And I know they're all out there, but if there was a one-stop shop with links to everything on the subcommittee's page, it might be helpful for the public. That's all I want to ask about.
Sure, I'll just respond to that, Mr. Robichaud. First of all, we actually addressed that just before you came into the room, and if you'd been in the room, I intended to acknowledge you. Thank you for your letter. We also acknowledge the fact that your suggestion of having the reintroductions, we did that as well. So thank you for your letter and those suggestions. I've asked Cynthia to look into that, either establishing a subpage on the website for the town or a Laserfiche location where we could locate all those, put all those documents so the public would have access to them. So
Beautiful.
thank you very much. We're on it.
Yeah, very much appreciate that, and I love the introductions. Thank you so
Great.
much.
And I'll
Great
thank you
job.
also for attending. I know you'll be coming later on, you, Mr. Kupfer, to do a presentation on the regulatory agreement. So
Yes,
we appreciate
absolutely.
you coming in.
Glad to be here. Thanks for the invite.
Great, thank you.
Good afternoon. I seem to be a regular at this podium. I'm Larry Morin from Katuitt. And I've really got two questions, and I'm really glad Felicia's here because one of them she may be able to elaborate. I'm concerned about the way the purpose was phrased in terms of the role of planning and this committee. So I think I'd like some, first of all, I don't know that you as a committee have discussed all of this. I don't think you have yet. But my concern simply is what appears to be the veto power of planning, which would nullify whatever you have done. In other words, it would get to the end. If there was a disagreement, it couldn't go anywhere. That seems to be not necessarily what I understood, and I think what many other people understood to be the purpose of the extent of this subject. This is a very, very, very complex subject. I think Chapter 240 wins the prize for the most pages. But that's not really why we're here. What we're really here is to help you define the role of zoning, and the question because how does planning have a role in that? So I don't know whether the intention was to have it be equal or whether it had something else. I'm going to leave that question open and let you all discuss it, or Felicia, if you wish to answer, I'd appreciate it. The second question that I have, or the comment I have, deals with enforcing. And enforcing in anything for which applications are required, whether it be conservation or Board of Health or ZBA or any of them, you either enforce by failing to do what the committee authorized you to do, or you enforce because you just disregarded everything and just did whatever you wanted to do anyway. The latter is probably the dominant thing on enforcing, but it seems to me that enforcing inherently is based upon something in the rule and regulations of the committee and/or within the application process itself. So you may want to consider distinguishing that as you move forward and decide how you want to react to enforcing. That may help you, it may not, but those are the two things that I wanted to bring to your attention today, and I'll be on call as we go through the whole thing. Thank you.
Thank you, Mr. Morin.
Hi, Eric Schwab from West Hyannis. And I always say West Hyannis because sometimes when you talk to people from Hyannis, they think about Main Street. They've got this little square in their head. And what people don't realize is that Hyannis is much bigger and much more diverse than downtown. And the problems we're having in Hyannis with respect to zoning are broad and varied. Downtown, you've got a height problem. You know, for whatever reason, someone decided 4.5 stories was a good idea. As you see from the outcry, most folks who live in Hyannis don't agree. So one thing I hope you look at is what's going on here downtown. Because frankly, no one who lives in Hyannis likes what's happening. The people who invest in downtown and live in Osterville, they like it, but the people that live here don't like it. So we hope you look at the zoning downtown. With respect to the data analytics that we did, thanks to Betty Lutke and Mr. Florence was extremely helpful. We're very appreciative. You don't have data that's actionable. Natalie alluded to this. My wife screamed at me over dinner 15 days in a row because she looked at the database also. She's a very skilled data analyst. And the two data points you're missing are close date and reason for close. Okay, you have a start date, but without a close date, you can't have duration. And if you just close an item and you don't state what you did to resolve the item, you really have no intelligence. So the data you have, unfortunately, is dumb, and you need to enhance your database by adding two fields, close date and reason for close. Then you can start doing analytics. So thanks to the work that Natalie did normalizing this data, I was able to manually go through it. And I just want to restate what the problems are, and you know what the problems are, okay? The biggest, most obvious problem is just overcrowding. There are too many everything on certain residential properties. There are too many cars, there are too many people, there are too many trucks. And the reason is because you're not really regulating basements. There was a case in Centerville just last week that was resolved. There were 14 people living in a basement with one point of entrance, right? Thankfully, Mr. Florence was able to resolve that. He put a team on it. They got the place cleared out. But this house now is a rental. It has open violations. There's unpaid fines. And the owner is interviewing the next tenant to come back in. Like, you're not saying, okay, enough, pay your fines, fix your problems before you put the house back on the market. You know, they just say, okay, next, you know. So you have created this round robin, and I can attest to that in my backyard. I have two, not just one, two commercial enterprises operating in the butter's property. One of them has a home occupation registered there, but he never lives there. He just puts his equipment and his staff there. And then his son came home from college and wanted to be like Dad, and they doubled all the equipment, just different names, same business. So every morning at 7 o'clock, the trucks leave because the inspectors don't get in until 8. And every day at 4:15, the trucks come back because the inspectors have gone home. Now, Mr. Florence has kindly made visits, you know, out of this sequence, but everyone has a sequence in their head. They know how to avoid the inspectors. They know what to do to not get caught. And if you do catch them, you don't do anything. You send a cease and desist letter, right? I've got copies of cease and desist letters that have not been acted on, right? There are no fines, there's no follow-up, there's no threat to remove a business license, there's no threat to remove permission to rent, there are no fines. So the one thing I sent you, Bob, Mr. Schulte, is a link to an article that discusses various legal strategies that are necessary in order to actually effectuate enforcement, right? You have to enforce in a certain way. There are laws about how you can have to complain. The town has to complain to the courts, get certain documents or decisions from the court, and then you can start the fine. And I'm sure that Mr. Florence knows this better than I. He knows zoning pretty well. But somehow we're not doing it right. We're not doing something right. And that creates the impression of inconsistency. It's like, you know, one guy's got 5 trucks and the other guy's got, you know, a pickup and a trailer. And it's like, why is one guy allowed to do this and the other guy does that? So it's because we're not looking at we don't have a method for consistently resolving these problems. If you have a certain problem, it should do. Here's the fact sheet. This is how you fix it. And we need license plates. We need to know who lives there. We need pictures. Tell us, the residents, what we can do to help you solve this problem. And then once you have the information you need to be successful, we expect you to do something. We expect you to clean it up, right? So that's where we hope you guys lead us. And we thank you very much for your time, and we wish you much success. Thank you.
Thank you, Mr. Schwab. Don't see anybody else in the room. Do we have anybody on Zoom?
We do, Mr. Chairman. Chris Gregory. And I'll have IT send him over.
Thank you.
Go ahead, Mr. Gregory.
My name is Chris Gregory. I spoke at the Ad Hoc Housing Committee yesterday, and today I have a similar message for you all. First of all, I'd like to point out that I have stepped away from work to make comment today. That is a luxury that I have that many people who are most affected by the lack of housing do not have and will not be able to come and make public comment at these meetings. So I hope that as you work, you are trying to get information from those people and about those people so that you are making informed decisions in their best interest. The next thing I would like to ask is I hope that this committee and the other committee are able to come together and make sure they align on the effects that they would like their proposals to have. I think that it's easy to envision that each committee could make proposals that contradict each other. And I think that if you are able to align on what we call in business SMART goals, specific, measurable, achievable, relevant, and time-bound goals, that you all can present recommendations that are all working towards the same end. For instance, if you're talking about affordable housing, define affordable housing, 60 inventory marked at 60% of market rate. You would like to increase that by X number of units over 5 years. If you want to make housing more affordable, you'd like to lower market rate by 10% over the next 3 years or something like that. You want to affect the amount of short-term or convert the number of short-term rentals to long-term by 10% over the next 3 years. To that extent, I hope that that's something that you will take into consideration and attempt. Those are even metrics that you could then continue on with and possibly even put up a dashboard so that the public can see what kind of progress the town is making towards metrics that are important towards affecting housing. That's the main thing that I wanted to get across. I do hope that you all come into this process with open minds and understand that in the serious situation that we have at the moment, that what has always been done is obviously not working anymore, and that new ideas and new approaches are necessary, and that there are no silver bullets to fixing this process. It will probably take a little bit of everything. And I hope that you will take a varied and thoughtful approach to housing in our town. Thank you.
Thank you, Mr. Gregory. Cynthia, do we have anybody else on Zoom?
Not at this time.
Thank you. I guess I'll turn back to the committee to see if any of the committee members would like to respond to any of the comments from the public.
Thank you, Mr. Chairman. A couple of things. I personally believe that Sorry, I apologize. I believe that overcrowding is probably the most serious issue in town right now, especially when it comes to Hyannis. I have a question for legal. Is there an ordinance where we can possibly enforce overcrowding by the number of vehicles in a yard, registered vehicles? For instance, if there's a two-bedroom house, three-bedroom house, and there's 14 cars, is there something we can do about that?
Thank you for the question, and building commissioner might be able to
Oh, okay.
address this as well.
Whomever.
I don't have our ordinances memorized,
Oh,
but that's
okay.
certainly a legitimate thing that we can do.
Can you make sure you use the mic?
Oh, I'm sorry.
Just so it gets recorded.
Sorry.
Thank
Kate
you.
Connolly, Assistant Town Attorney. That is certainly something that can be regulated. I don't know how it affects the number of people living in the apartments. I don't know that you can limit, however, 8 apartments, 2 cars per apartment, but certainly based on, we do have parking regulations. I know we do have certain requirements in certain districts that there be minimum numbers of parking spaces and sizes of spaces are outlined as well. I'd have to take a look at our ordinance, though, to see how it might need to be tweaked to address what you're looking to do.
Because
Do you wanna-
the reason why I mentioned 14 cars is I drove through my precinct last Saturday, and there was a two-bedroom house, about 1,000 square feet, with 14 cars parked in that yard at 6:30 at night.
Wow.
No parties or nothing. 14 cars. And, what's happening is that when I bought my first house at 23 years old in Hyannis, there was nothing like that. All those neighborhoods, for the most part, were pristine. But now you drive through those same neighborhoods and you find, as Mr. Schwab mentioned, full-fledged businesses. Not pickups in a trailer. You see tractor trailers parked in people's backyards. You see they will put fences in the front, do a stone driveway going to the fence, and in the back you'll see storage trailers, trucks, metal, and some of them have, as I said, several vehicles. You go by any of these roads in Hyannis, you'll see 10 cars on a yard, on the grass, with cars in the driveways and so on and so forth. So to me and to my constituents, and I think to the town in general, with the things we're trying to do with, not trying to get on a different subject, but wastewater, sewage, this all plays into that. And we really need to do something to stop the overpopulation of these houses. And it's the same houses over and over again. They're not really new ones creeping up every week. It's the same houses over and over again. So I was just wondering if there was anything we can do about that.
I will defer to the building commissioner for more detail. I know that with new development, you can regulate the number of parking spaces per unit and that sort of thing, but what you're talking about sounds more like, and you had mentioned this at the last meeting, which is probably why I gave my example of the bylaws I've seen out in Western Mass for, that's not the same as parking, but if you dump a car on a property, I suppose you could consider that parking. But that is an issue that a lot of towns have dealt with, and that's why some of them have adopted ordinances or bylaws that regulate how many you can have on a property.
Yeah, because I know that there's the unregistered car, but that's why I
Yeah.
specifically mentioned registered vehicle.
Registered, so, yeah, parking.
Good afternoon, Mr. Chairman, committee members. My name is Brian Florence. I'm your building commissioner. The answer to Mr. Mendez's question through you, sir, is Chapter 59 is our occupancy limits ordinance. It's in your general ordinance. It regulates the number of people in a building and the number of vehicles that are allowed within a residential structure. The problem is that Barnstable has brought this to court and we lost. I recommend that you talk to the legal department to find out the specifics of the case, but we specifically tried to, and I wasn't here at the time, this was before me, we specifically tried to limit the number of vehicles based on that ordinance, and we were told in court, no, you can't do that. The judge also told us, and again, we'll have to look at what the case and the specifics of the case, that they didn't adjudicate the issue about the number of people, but they had a problem with that as well. So the vehicle issue was shot down in court. There may be a way to fix it, I don't know, but that's something that you folks will need to look into.
Mr. Florence, can you tell me, do you have any idea how long ago that litigation was?
I don't. It was before me, and I got here in 2017.
Okay.
I don't even know what the date.
Attorney Conley, this is before you too. Is that something, since it sounds like legal could probably give us some more color on that and report back at the next meeting? Okay, thank you.
That was a 20-year-old ruling in Osterville. And the town's been hanging its hat on that ruling.
Yeah, you want to come up? Thank you, Mr. Schwab.
This is why we've repeatedly asked for the list of court cases the town has lost. Like, if you're losing in court, then just show us where you're losing so we can look at it and understand, we'll map it to the data and come up with a solution. The excuse they're using for cars parked in your front yard is one case that's over 25 years old that occurred in Osterville. So, it's like, okay, that was 25 years ago. Maybe we can revisit. Maybe we can come up with a zoning strategy that allows us to go to the court and win. The article I sent you, the link to Mr. Schulte, specifically discusses how you have to approach cases like this to win. Because ultimately, you're going to have to win in court. And then once you win, we've talked to Mr. Mendes about this, once one guy gets told to clean up, the whole street's going to clean up. You only got to take one guy to court and win, and everyone's going to get the message. So you need to look at the legal strategy, and if you need help, just give me the list of cases you've lost, and let me look at it, and we'll map it to the data. We'll try to help you. Thank you.
Okay, thank you. Maybe we'll start with Attorney Conley. If you could find some more information out about that specific case, and Mr. Florence, we can maybe send that information, and Mr. Schwab, maybe that's something that your group could look at as well. Councilor Crowe?
Thank you, Mr. Chairman. I happen to remember that case. It was a Spenlenauer was the name of the person who owned the home. He owned a small cape on Seaview Avenue towards the end where the cut is. And behind that property, there was a bigger piece of land where he built what I believe was a garage for all his cars. So he won that case not by having all those cars be residents at that. I think he owned all those cars himself, and it wasn't an overcrowding situation either, because it was just he lived in a small cape with his two sons and his family, and what he built behind it looked like a barn with many garage doors. So I don't know. I think you should look into that case and find the specifics about it, because it may not pertain to what the main problem we have is overcrowding.
Just a question for Councilor Crowe. So he was a car collector?
From what I understand, yes. They were all his vehicles.
Okay, because you were going to lose that case every time.
Yeah.
If he's a car collector.
Yeah.
Absolutely. Okay. Yeah, people do that all the
I would
time.
check the facts. It's been a long time, but I remember the name of the person, and I remember he had built something behind his home that was in a larger lot that was barn-looking, and it was in almost like a quarter circle where he had many garage doors, and I think he collected cars and kept them in there. But I don't believe there was any overcrowding going on. So it's a different issue, I think, in that case versus what we're talking about. And I agree, both with the overcrowding and the cars, this is something we should be able to regulate on a regular basis. At least I would hope so.
Commissioner Florence?
Mr. Chairman, if I may, there's an unfair characterization being spoken here that we don't enforce against the cars, we don't enforce against the overcrowding. We absolutely do. I can show you several cases, the committee, if you'd like, we can pull those aside for you and show you that we've done that work. I'm just saying to you that there was some complications with the ordinance. They asked what the ordinance was. I identified the ordinance for you because I know you're trying to work on ordinances, and I told you that I just gave a qualifier that there's some complications with it, and we've run into them in court. Okay?
No, I appreciate that. I'd like to think with the research Attorney Connolly can do on that specific case, and maybe the two of you can talk, and I think it's a fair request to say what works and what doesn't, why are we losing, why are we winning. Obviously, you just said that there have been some situations where you're successful. Maybe a little bit more color to the committee so we can understand. Maybe we can help get some other ideas that might help you be more successful in some of those enforcements.
Sure.
Thank you.
Thank you, Mr. Chairman. I just wanted Mr. Florence to know there's no way that I'm insinuating you're not trying to enforce, because you've shared cases with me. So I've seen where we've tried to enforce and we've lost. My whole point is that we have to take a holistic approach. We have to possibly take a new approach and try to do an end around, because this is a serious, serious problem. It not only affects our environment, but it affects people's property values. And people have worked their whole lives to be able to afford a little piece of this Cape Cod, and it's not fair to those people that their property values are being driven down. With some of these people, this is their only, big investment, per se, that their properties are being driven down by neighbors who choose to flaunt the rules. And it's gotten to the point now where they don't even care about the rules. They don't even care about them. They like I said, you drive through Hyannis, and I drive through my precinct often at the behest of Mr. Schwab, because he told me to check it out, so I started doing it. And it's very, very troubling, because it's not only in one neighborhood, it's in every neighborhood. Every neighborhood. So it's very troubling. And there has to be some way we can go about at least wrangling this in somewhat, because it's gotten to the point now where it's like I said, it's...
Comment if I can.
It's terrible. It's awful. And I'm not blaming you, because I know you're only one department, and I know that we have lost court cases, so I just want to try to have a holistic approach to this and try to get to answers.
Thank you. Mr. Osman?
Yeah, this is not something I'm really very familiar with. Doesn't mean I won't comment on it, but it seems to me that has there been any public PR on this? Any newspapers picked it up? Anything sort of bringing it to the light? It's nothing I've heard of, to be honest with you. I don't live here in Hyannis. I come from California, and if you understand California, and one of the reasons so many of us left was that things started to go in this direction. And it was the failure of the courts. When you could do all the enforcement you wanted, but by the time you get up to the courts, they'd say, okay, good, you shouldn't do that again. And it became very difficult. My son lives in Oakland. Anyway, those sorts of situations lead to real problems in the neighborhood, as has been suggested, and it leads to a flight of people who would rather stay there. I do think that some sense of the newspapers picking it up or something like that would be helpful to begin and help the fight.
Thank you. Councilor Bloom?
I don't want my fellow Councilor Mendes to feel like he's the only one in Hyannis who is upset about the I support you 100% in everything that you've said. And the only solution that I see happening is we build higher houses, more density, more cars, inviting more cars, giving them less parking spaces. We are on a collision course with density that is going to destroy our town here, our village, the village of Hyannis.
Councilor Penn?
So I'm going to bring this around to land use discussion. And when I was participating in the local comprehensive plan update, it occurred to me that in some of the breakout sessions, some people on the committee kept saying, we got to build this, and this here. And they were identifying Independence Park as the here of where to build everything. And I'm just standing there shaking my head, no. Independence Park needs to be preserved for the workers in the town of Barnstable and of all of Cape Cod. It was originally intended for tradesmen so that they had a place after they graduated high school or after they came out of the vocational schools. They had a place to set up shop, their own business, if they chose, with other plumbers, with other electricians, or just themselves, so they could earn a living for their family. And so they did not denigrate the neighborhoods where they lived. So it was set aside for those uses. What's happening now, and we've heard this from Council Ludke at town council meetings, we've heard it from other people. What's happening now is that the tradespeople bring their trucks home, 2, 3, 4 of them, whatever it is. They wash them in the driveway, they do this, they do that, they do the maintenance on them, et cetera, et cetera. All those uses used to happen in Independence Park. But this town, unfortunately, in its eminent wisdom over the last 10, 15, 20 years, has rezoned that property for retail, big box retail, for housing, for other purposes that take away from the original intent of that property. Drives me crazy, because the long-term vision and the long-term goals is exactly what we're talking about here, the fallout from the fact that they don't have a place. So the other day I was talking to the town manager and the assistant town manager, and I basically said, we need to find these people parking lots and or open space or something in the off hours that they could go park their vehicles there, take their cars, go home. Maybe their vehicles have to leave by 7, 7:30, 8 o'clock in the morning. Maybe it's the school property, et cetera, et cetera. But we need to get smart about it, because we've already given the original property away to developers. It was just short-sightedness on our part. And we need to preserve the place in our community, not just for Hyannis or the town of Barnstable, but for the whole Cape. We need to preserve that place for the tradespeople and individual business people, whether they're doing auto repair. I mean, I don't care what they're doing. We need to be true to that and uphold that, because otherwise, once the last parcel of that goes away, you think we have a problem now? Oh my, it's really gonna, where are they gonna go? They can't afford to buy all that land. So, you know, Mr. LaRusso, who started Independence Park with about 6 other business guys on the board, good for him for having that vision. Good for him for dedicating the future to the workmen who make our lives possible and work their butts off every day and do it right. So I'm just going to put a little lens here on land use, which is, I know it's a big category, but it's something that is the underbody of everything that we're talking about here. Every time there's overcrowding, it's a symptom of something. Yes, it could be because housing is expensive, but it also could be because they got no other place to put their trucks anymore, because we've sold it and turned it into something else. I mean, I understand the people who developed Hanover House want to build another big housing development and a hotel in Independence Park. And when they told me that, I looked at them. They must have thought I had eaten something nasty. The expression on my face, I said, seriously? You're going to build a motel in Independence Park? And I'm thinking, you know, if I was living in Pennsylvania or Kansas or Maryland or wherever people are coming from to visit, and I drove to my motel and it was in a industrial area, You know, I'm coming to Cape Cod to go to the beaches. I'm coming to Cape Cod to do beachy things and to get away from all this stuff. Why do I want to stay there? And why do we want to give that property up for that purpose? I mean, I don't know. I'm a realist when it comes to, I'd like to see the townspeople and the tradespeople shown some respect, because I think they're doing the best they can in most cases. Now, the people who grossly and intentionally overcrowd, that's a whole different ballgame. You know, that's a different thing. But the people like Betty's talking about who bring their trucks home at night and wash them, you know, 4, 5, 6 trucks, and then they go, I don't know where they go with them. What do you do with them? You know, so the town either has to come up with some place that these people can go and get all this stuff done that's not in a residential neighborhood, or we need to return the land use to what it was for originally purposed. That's my tirade for today.
No, appreciate the insights. Going through, just want to thank, is there any other comments from the committee?
Just one really quick.
Sure.
I'm sorry, I usually don't monopolize time, but I want to thank the council president because what she's saying is absolutely true. Because I remember when Independence Park was nothing but tradesmen, and we used to ride motorcycles down there. Yeah, it is. Yeah. I have a habit of drifting.
He didn't want you to hear that part.
Yeah, we weren't supposed to ride motorcycles down there. But anyway, we do have some town properties that may be able to be used for just what you're talking about, Felicia. And we could actually monetize it.
Hmm?
Charge a monthly fee for people to park their vehicles there.
Something very reasonable.
Yeah, absolutely. So that's all.
Thanks, Chairman. In my village, Ostville, right in the center of the village, next to the post office, the library, and the bank, there's an empty lot now that's owned by a fellow that owns a nursery. He is now putting all his plants on that lot that are there to be sold and everything else. So it's right, he has his business up the street where Old Busch Gardens is, and he has all his product down right in the middle of the center of the village. So we understand the problem here too. In Ostville, same thing. And also we have overcrowding in our village also. I think, Brian, what we were trying to get at is not to talk about what we've done in the past, but try to find a solution for you and sort of a formula that we could, a legal formula and strategy that we can go back to be a useful and a regular basis for these properties and that's successful. So what we want to try to do, I believe, is come up with that strategy, and so that our cases that go through the courts will be successful and have test cases and work off of there and come up with a template. And then we can go on a large scale and work on these problems. So I think that's what we're going for here, and hopefully that we can do. Thanks.
Sure. Councilor Florence.
Thank you, Mr. Crow. And Mr. Chairman, I only enforce what you give me. You folks, you give me rules, I read the book, I enforce it. So whatever you want to do is fine with me. It doesn't matter the regulation you give me. I do ask that if you're going to create regulation, you consider the funding source for it. And also, if you create regulation, we make sure that we do it in a way that it's actually enforceable and is going to be successful in court. So I understand that that's what you're doing. I thank you for it.
Yeah, we're going to need your help in doing that because you've had the experience in court that we've not been successful. We're going to need our law department and also your help in working on other strategies and in trying them out until we find something, hopefully within the next short period of time, that actually does work and have some test cases and then get us all together towards that goal. And then we can replicate it on a large basis. So thank you.
Sir, I took an oath to
Yeah.
uphold the rules of this town and do this job, and part of that job is to help you folks, and that's what I'll do.
Oh, I appreciate it. Thanks, Brian.
Thank you. I'll just follow up on that. I just agree, Councilor Crowe. I think we'll take a cue from what Mr. Gregory said. You know, we want to look at new ideas, maybe what has worked, what we've been doing hasn't worked, and no intention to mischaracterize anything. You know, Mr. Florence, we're just trying to move forward and come up with ideas. And again, nothing, this group is not going to give you any regulations. All we're going to do is make recommendations to the council for they and the planning board to consider. So If there's no other comments from the, Councilor Turkelson.
Thank you. I feel like is my microphone on? Okay, I just can't hear it, so. That's my comment, when I said we should invite Brian to come is, the part that you say is it needs to be, whatever we're making needs to be enforceable. So I think that's what John is speaking about, is making sure that, that we're handing you something that can be utilized, and I do look forward to that. And I also thank Natalie and Eric for their data. I know you said you've worked in some of the villages. I think you have shared that data with me, so I'm going to go back to that this weekend, because I'm assuming that's where Jeff got his drive around and then check out some of those properties in my own precinct. So thank you for that information. And if there's other counselors that you haven't shared it with that you have the data for, I hope that you'll share that with them and maybe make a recommendation like Councilor Mendez said, drive around and check some properties out. So thank you.
Great. I know we want to leave enough time for Mr. Kupfer and Mr. Robichaud as well. Just real quickly, I think, thank you, all the public commenters. I think everything was really pretty much discussed or addressed. There's only one item. Mr. Moran mentioned something about, the role of planning and maybe what was envisioned by the committee. And President Penn, I don't know if you have any thoughts how the interplay between planning department and this ad hoc zoning committee, if you had any thoughts on that. My understanding was it's more that we would make recommendations. Some of those would be reviewed by planning and development as well, or the planning board. But if you have any thoughts on that.
Yeah, the original thought about that was the fact that this group would come up with or suss out some problems, throughout the town. Like we just talked about the land use for Independence Park, for example. When it came to specific zoning issues, such as, with the form-based code stuff, we have a map that shows the color of a zone from one street down here to a street over there and then a side street over there. But the language of the actual zoning says that X, Y, and Z only happens on this part of the map, not on the whole colored-in part of the map. So, it's stuff like that I think this committee should chew on and say, hey, we don't think this satisfies the intent of the original intent of what was sold to the residents here, and we think we can improve it by doing X, Y, and Z. And then we would take that, discuss that with planners,
okay,
and see, if we're going awry anyway. And then they can discuss the actual language, maybe. We'll have legal here. We have the building commissioner here, people who enforce and write things. Juggle it all down, mush it out, and bring it to the council as a suggestion. Okay. I mean, that's the general idea of, I was thinking of how the process might work.
Okay, thank you.
We can improve on that, obviously, but I just think that there's quite a few issues that caused this committee to be formed, and a lot of them are pretty easy. Like, if language limits activity in a zone to this area, but the zone is actually 6 times the size of that area, it's like, what's the point of that? Whose idea was that? I don't care whose idea it was. Actually, that's not important.
Yeah, just identify the issue.
We're not here to rub noses in anything. We're just here to improve things.
Okay.
Make them better.
Great, thank you. All right, unless there's any other comments, I think we'd like to turn it over. Welcome Jim Kupfer, Interim Director of Planning and Development, and Steve Robichaud, Chair of the Planning Board, to give us a presentation to help better understand the regulatory agreement process.
Hey, all right. All right. Good evening, everyone. Jim Kupfer, Interim Director, Planning and Development, here to talk regulatory agreements. I think at the last meeting of the subcommittee, there was questions as to, what truly does this ordinance say? It's a kind of convoluted ordinance, Chapter 168, regulatory agreements. So today I'm hoping to just speak in plain English as to what the ordinance intent is, how it was formed, the process, and Mr. Robichaud, the chair of the planning board, is here, who can expand on kind of the recent occurrences of regulatory agreements. So before we get into regulatory agreements, it's important to know that this is really separate and distinct from zoning. So Mass General Law 40A is what establishes zoning. So in Massachusetts, Mass General Law 40A really outlines what zoning is, the zoning enforcement officer, the building commissioner, things like special permits, variances, pre-existing non-conforming uses, et cetera, et cetera. So this is kind of the big picture of how zoning is established. And then in Massachusetts, we're a home rule state, which means that we can make our own zoning locally. And not every state is like that. There's Dillon states as well, as Ms. Ledeck certainly knows. So in Massachusetts, home rule, we can then create our local zoning. And as you've heard from our attorney, that local zoning can match or be stricter than the state, but it can't be in conflict with the state. So we established our local zoning, and our local zoning is under Chapter 240. And what we've heard already today, it probably is the longest section of our ordinance or of our code. So there's Mass General Law, and there's our local zoning, and our local zoning sits in our code as Chapter 240. And then separately, Chapter 168 sits regulatory agreements. Regulatory agreements are a separate tool for land use. And they interplay with zoning some, and I'll explain that, what I mean by that in a little bit here. So this regulatory agreements are a separate and distinct tool. It really is truly an agreement. It's a contract between two parties. So I will go over briefly the authority, regulations, the content, purpose, all of its applicability, our process, and Mr. Robichaud is here to expand on experiences. So as our zoning code is, the authority stems from Mass General Law 40A, regulatory agreements stem from the Cape Cod Commission Act, and then truly, again, home rule authority, again, we can tweak it and make it our own. The regulations mimic, and I'm sure Ms. Penn can expand on this after, regarding kind of how it came to be. But the regulations do mimic that of the Cape Cod Commission. A lot of this language you see here stems from Cape Cod Commission language. And then again, because of home rule, we're able to make it our own in our town code, Chapter 168, and that was done in 2004. So what is a regulatory agreement? The regulatory agreement is voluntary, so there's no requirement for the town to enter into an agreement, but it is a binding contract. So once you do enter into agreement, there are specific terms that are identified. And I know I provide this group with 5 examples of those contracts. It establishes development regulations that apply to all the property, that apply to the specific property. And development regulations meaning, heights, setbacks, landscaping requirements, et cetera, et cetera. There's also conditions that are likely going to be established in each one of these contracts. Conditions such as, prior to building permit, you need to, connect sewer line or something to that effect. Or, the road needs to be repaved, those types of conditions. And it establishes a term and duration. So you have 5 years to implement this. Contents will establish, as I mentioned already, permitted uses, the densities. Really, every aspect of what's going to be on that property should be outlined in either in this agreement or the applicable plan that's associated with it. These are all then recorded at the Registry of Deeds. So really, what the regulatory agreement section was established for was to create an agreement between two parties And that agreement will establish all the development uses and amenities on the site. And in turn, the town will seek a public benefit. So what is the benefit to the community that we are going to enter into this regulatory agreement? And when I say we, and I have it in another slide, but we being the town council ultimately entering into this regulatory agreement. So there needs to be spelled out, and you'll see it in the contract, the agreements that I provided, what the benefits are. Those can vary dramatically depending on the ask. So just like any contract negotiation, there's a proposal being made, and there's a request for that, and so they need to match up. So, it's ultimately up to the planning board and the town council to negotiate those terms. Public benefits, straight from this ordinance, are those 9 there. Public benefit, improving, town infrastructure, capital facilities, maybe land dedication, employment opportunities, affordable housing, community facilities, recreational facilities, alternative methods of transportation, and really anything else that, that maybe is rising to the top at this day and time. So really, it's meant to be a flexible tool. So again, a regulatory agreement, non-binding, an applicant comes and says, I want to do something spectacular for our community, and it's just simply not allowed in our zoning. It allows for the town to consider it. That's, I believe, initially, I believe that's what it was meant to be. Whether that's come to play, we'll see throughout our examples, and we'll see throughout the time over regulatory agreements have been established. But that's truly what the tool, from reading back in history, I believe that's what it was meant to be, to help revitalize downtown Hyannis and having this opportunity, this specific tool available. It also was meant to streamline permitting. That is also questionable whether or not it truly streamlines permitting. I will go into that in just a moment. So the applicability. So the applicability is for any property owner in the regulatory agreement district. Any property owner in this district can come to the town and ask for this agreement.
Jim, real quick.
Yep.
Does this one work? Yeah, it does. Do you mind highlighting the 2 areas that are outside the growth incentive zone? There are 2 areas there on the map. Can you just identify those for us?
Well, this thing doesn't show up on there, but I think everyone's familiar with. So you'll see the growth incentive zone, which is kind of the big block there. And I do want to add that it's the growth incentive zone, but it starts to further out to Twin Brooks Golf Course. I want to highlight that. And I have all the dates for which each of those were established. So there is expansion into, so the growth incentive zone was the original district in 2004. There was expansion near the airport, which is still within this boundary here, in 2007. In 2012, Twin Brooks was added. Before we get to 2012, in 2009, the small area on Centerville Main Street was actually added. And I have the intent there. I pulled all the town council records so I can distribute that to everyone. And then lastly, in 2018, the Kmart Plaza was added. So what is now being redeveloped by WS Development. So this is the district that stands today. And so any property owner or developer representing the property owner can come to the community and ask for this agreement. Again, the town doesn't have to consider it if they don't want to, but it is a tool that is available at those properties. Qualified parties are, again, the applicant being those that own it, and the town of Barnstable. There are other agencies that can play a role, but for our purposes, it's the town of Barnstable. So the process, the lead negotiator is the planning board, so it starts with the planning board. But more recently, and it sounded like from Ms. Penn mentioned at the last meeting, they may have done this in the past as well, but recently, if any interested party is seeking a regulatory agreement, It tends to start with the department, so we'll get a call and we'll say we want to enter into this agreement, and I will then contact both the planning board chair and the president of town council and say, there's a agreement being sought. Do you want to sit down with the applicant and discuss this? And so those members of leadership may sit down with the applicant and say, you know, what those options may be, or just say, here's your process, you're welcome to go at it. I think from my standpoint as an administrator, I would love to, if we're going to look at the process, that would be something I would really, truly like to improve upon. The introduction of a regulatory agreement and getting more people involved earlier, because ultimately, you know, it doesn't do anyone, not the town or the applicant, any service for going through maybe a 9-month process ultimately to be denied at the end because, you know, it never stood a shot in the first place. So how it is in the ordinance is written, planning board is the lead negotiator. The planning board holds a public hearing, and ultimately, if the application receives an affirmative majority vote to recommend the execution of the agreement, it will then go to town council. If it doesn't receive that majority vote, it dies right there. And we've seen that recently. The planning board was not in favor of a recent regulatory agreement, and it did not move any further. Now, if it does receive a majority vote, it then comes to town council. Again, that's a public hearing. Typically, I believe it's first read and then goes to second read, and there's a public hearing with discussion. If there is, the reason why it says majority or 2/3, it depends on whether or not a waiver is sought to zoning. Almost every regulatory agreement is seeking a waiver from zoning. That's very likely why they're there, applying for the regulatory agreement. So very likely, there will be a 2/3 vote by town council. And, you know, ultimately, that's where, if it doesn't receive that 2/3 vote, it doesn't go to the town manager. So if it does, so that meant if it's got to that point, that means the planning board has reviewed this in a public hearing and given it a thumbs up. It's gone to town council. They have also agreed to it. Now it goes to the town manager. The town manager signs the agreement, the contract. And those are the terms in which the developer will proceed with his development of that site. Now, there's amendments. There's another section in the ordinance for amendments, and I just wanted to quickly touch on this. So you now have an agreement in hand, a contract in hand, and you know you get out on site, and there needs to be an adjustment to the site in whatever way it may be. The stipulation there is that an amendment can be made, provided that such amendments do not alter the use, intensity, or mitigation stipulations of the regulatory agreement. So I don't believe I've received an amendment that does not impact one of those. I know we have gone through some major amendments in the recent past, but I don't believe I've seen a minor amendment. I'll double check my files and see if there's anything prior, but that's the trigger, provided that such amendments do not alter use, the intensity, mitigation of the regulatory agreement. So, since 2004 is when this was established. We've had, based on our records, we have 23 regulatory agreements. That's the full list there. I provided five that I try to vary in use and age to give you a sense of you know the range that is available and has been sought. And so the most recent one is 442 Main Street. They're actively under construction right now. That was the old I think Rockland Trust that was vacant for a number of years and is going to be commercial on the first floor and residential's above. Prior to that, I believe in 2021, perhaps, it was 80 Pearl Street, which is a small multifamily. And so, you know, you can see the full list there. And I'll turn it over to Steve if he has any additional items.
I'm not going to go to the podium. I'm going to park it right here. So I thought that was great. Really good overview. I have kind of an overview, some comments I put down. I will clean this up, type it up, and share it with all of you so you have it. But I just want to share some information, some of my experiences, and offer any answers to questions you may have. So again, as Jim said, we've got a flexible tool here that the town can utilize. As mentioned, it requires both planning board and town council to approve. So this is not something that is solely owned by planning board. It's a joint responsibility with town council. Prior to, I guess I should say, it has not always been a predictable result for applicants. Planning board could love it, town council could hate it. So it's just one of those things where it sometimes has been challenging and has been frustrating. For me, it can be kind of a love-hate relationship. Some of them are no-brainers, and it really makes sense. And on that list of 23, you're going to see plenty of those that we really, I think the town is and should be proud of. Some of them were, just polar opposite viewpoints, very controversial, a lot of public input, and so it can be challenging. Form-based code has made a big difference on this, and I guess before I get into that, I did write down here, it is an excellent tool for the town to have in their back pocket. It's definitely something that's kind of good to be there, whether it's used or not. I think it is an excellent tool to exist for the town to have, and I believe we're the only town on the Cape that has this ability. Is that correct? I'm almost positive we are. Most everything else, development agreements would go through the commission. So the commission has granted us the authority to do our own development agreements within that map, which is kind of a unique thing. So again, form-based code changed things quite a bit. We used to see a lot of regulatory agreements that didn't necessarily abide by the local zoning or ordinance that needed that flexible regulatory agreement to make it happen. Now, with form-based code, form-based code is allowing a lot more density. It's allowing people to maybe not need to seek those waivers that they needed to in the past, so they're able to go forward with by right projects. And the review of that now switches to, well, I shouldn't say switches to, but the focus of the review is site plan review. More flexibility. It has, again, vastly reduced the number of regulatory agreements. We've had one regulatory agreement since form-based code went into effect, and that one was dockside, which we did twice, once before and once after form-based code. So that was a unique kind of experience. Wanted to give some examples that I kind of just wanted to highlight. 442 Main Street, I thought that was a good mixed use result and a good use of a regulatory agreement. The Walgreens, 68 Yarmouth Road, 80 Pearl Street, 77 Pleasant Street. And again, I'm going to send this summary to you so you can do some research on those. But some great projects that have allowed for excellent housing production, some great mixed use, and a lot of things that I think as a town we can hang our hat on as a success. For me as chair, I try to emphasize from the very start that this is a negotiation and we're looking for a give and take. I demonstrate to the applicant what's important to me, but I'm just one person. I'm one member of a 7-member board, and there's 13 town councilors. So there's a lot of people who have a role in this, and when it comes to mitigation, I think it's more important going forward for us all to share our voice from the very beginning of what's important to us. So the mitigation examples that Jim gave, I wrote some down myself. Mitigation, again, if somebody is asking for something, we got to get something in return. And what we get in return has to have public benefit. And that's what that negotiation is. Some examples: cash, infrastructure, donations to the housing trust, open space, recreation, preservation, and affordables. So that making it apparent to the applicant from the very start what is important to the town, what do we need to get in return, I think is critical to this process being successful. When I first joined the planning board, I didn't feel that there really was a lot of push to get a lot or something in return for those waivers. And the other aspect of it that I didn't really see a lot of was focusing on the design. So I wanted to talk about the design guidelines. A lot of you may have heard about the design guidelines. We're looking to create a unified design guidelines between the Hyannis Main Street Waterfront Historic Commission as well as the Planning Board. We did have some joint meetings, and Planning Board did adopt new historic design guidelines. And we're going to be meeting again with the Historic Commission. They wanted to do a little bit more work on it, and they have. So we're going to meet again to work on that. But why that's important for this conversation is for the Planning Board, regulatory agreements and special permits rely on the design guidelines to direct an applicant for how they are to proceed. And I didn't, again, when I first joined, I didn't feel that that was a big focus for applicants. And with these stronger, more specific guidelines, we're going to see developers knowing from the get-go what they need to do to make sure that it meets the character of our town. Again, guiding the construction design details of the job, helping to bring about that predictable result, and really, all I had to go on when we first started was these words, upholding the maritime and historic character of the town. That just wasn't enough, you know what I mean? And I dug in, but I felt I was a lone voice in that. So now that those guidelines are enacted by the Planning Board, and now that, the work that the Main Street Historic Commission is doing is phenomenal, and I think when we finally have a unified vote on that, we're going to get a really strong product out of that. And, I don't want to jump too far ahead, but there are a few things in there that I also think will ease some of the angst and concern about some of the form-based code items. Some things that talk about ceiling height, some things that talk about the length of a structure, some limits to that. I know both Cheryl and Tom on that commission have put a lot of work and thought into that, and I think that'll be good for all of us to take a look at. I guess the only other thing I wanted to mention is I have a couple, ideas, thoughts that I wanted to put out there. Again, I think it's important for when an applicant steps to the negotiation table for them to know immediately from the start what is important to every single town councilor in terms of mitigation. What do you want to see? One way that could be done is a survey could be sent to town councilors to get those responses back so that as chair and as the planning board, we can say, look, if you're going to ask for a list of 15, 20, 25 waivers, here's what you're going to need to demonstrate. And, there's basically getting them to really step up to the table. We talk about demonstrating the public benefit. I have to be perfectly honest with you, whenever that is demonstrated to us in the first meeting or two, it is about as lame as you could possibly get. And some of the things are just like, really? Upgrading the sidewalk in front. Well, yeah, of course. You know what I mean? Right, we're going to provide one job. Okay, great. You're asking for 30 waivers. You know what I mean? So I think I, as chair, and our board need to have your voice behind us from the start so that we really can negotiate on your behalf. That's our job. Our job is to work on your behalf and give you, hopefully, is what is a good product that you can put your stamp of approval on. Because, again, these things can be brutal. We can look at 3 months of work and deliver something that we might be happy with, but it could get turned down at town council, and that's a lot of wasted effort, not just by the applicant, but by planning board, the public, a lot of players. So, again, someone's going to come to us with requests for waivers. They need to demonstrate that they're meeting your wishes and your desires for community benefit. And that's about all I got. I guess the only other thing I would mention is, as Jim mentioned, part of the process, we've got to find a spot in the process for town council feedback. We get plenty of feedback from the public. These are very lively meetings. On a personal level, that they are my favorite because it's very engaging and lively, which I really enjoy hearing that public back and forth. But, you know, I don't see any reason why after a meeting or two, we couldn't pause to say, let's get some individual feedback from town council, or even have it on the agenda as a non-binding discussion, not something to vote on, just something to discuss. You know, there's going to be things where you say, this is a non-starter. You know, Dockside was a very intense regulatory, twice. Pre-form-based code, post-form-based code, and it was very intense. And you know, I said to Jim, there's no chance anything over 3.5 stories is getting past town council. So if it's more than 3.5 stories, why are we bothering? You know what I mean? So, but we forged ahead, and you know, granted, it didn't make it through planning, but I know it wouldn't have made it through town council. So why waste that time? Why not have you step up to the mic and say, this is my line in the sand, go back and work on this. And of course, we now have a by right 2.5 stories. So we know that 4.5 wasn't necessarily the end of the line. You know what I mean? That negotiation could have continued. So anyways, I could go on and on, but I think that's kind of my thoughts I wanted to share. Again, I'm going to take all my messy notes here and organize it into a tight document to submit to you to have for your review. And again, thank you so much for inviting me. And I'll take, you know, if anybody has any questions or comments, I'm happy to share and help.
Sure, I'll just first thank Jim and Steve for the presentation. It was great. We really appreciate helping us understand the process. I guess I'll look to the committee and, okay. Okay.
Thanks, Jim and Steve, for your presentations today. Very, very helpful. I have a lot of questions. I'm not exactly sure where to start, so I'm going to start with the presentation that Jim made, and then I have some questions for you, Steve, too, and then maybe I have questions for the staff, too. I don't really know. Anyway, in your presentation, you talk about this process. You have this slide for process. And you said that when a developer or a landowner wants to enter into one of these regulatory agreements, the first thing that they do is they come to you and they say, I'm interested in doing this. So is there any interaction with the public prior to that? Or shortly after you've spoken to them? Is there any interaction with the public?
No, not in accordance with the ordinance. There's the first step is planning board, and that's where the interaction begins, the public hearing. So it puts the public on notice, hey, there's someone interested, they want to enter into an agreement where the planning board is the lead negotiator. They're going to be meeting right here at this time. Come one, come all, let's discuss this.
So it could be that somebody in that public hearing, that's the first time anybody's ever heard about that. And there may be something controversial about it, right? Maybe half the people in the room don't like it. And that's a formal public hearing. So you've gone through a formal process that's not been well received, right? So doesn't it seem to make sense, and I support your comments, Steve, having these open discussions about these projects before you have to take a vote on it? What you don't want is to put a lot of work into a project, bring it to a vote and a public hearing, 3/4 of the room don't like it, everybody behind the dais votes against it. You know, it's sort of, you're kind of working against yourself because these regulatory agreements are supposed to work in our favor for the public benefit, right? So what's missing from here, in my mind, is interactions with the public and discussions about these projects before you begin the formal process. I've seen projects like this go through in Virginia, where I used to live. The best ones were the ones where we as the community were involved 2 to 3 years before it got to the formal process. And that way, once it gets to the planning board and to the town council, everybody loves it because all of your concerns have been addressed. The design of the project meets all your goals, the environmental mitigations have been done, and everybody votes in favor of it. So that's something glaring that's missing here in my mind, is the public interactions. Because the public, they're the ones that are going to have to live with it, right? You want to make sure you hear from them. And they have valuable input to provide that needs to be incorporated into the design of the project. So that's sort of the first comment that I have to make there.
Can I add just one?
Of course, yes.
I did want to just express the fact that, in my experience, regulatory agreements typically are many, many, many meetings. So I 1,000% agree with your comment. Absolutely, get the public involved as early as possible. But I did want to make sure that I gave the right impression that it's always a multi-meeting type of event, and we always allow public comment and republic comment. Even if it's the same message, we don't stop anybody.
Well, sometimes somebody misses that public meeting and they didn't get their comments out.
Well, but again, that public hearing is at every meeting we have, and I see the average between 3 and 5 meetings. Yeah.
Right. Okay, great.
But to that point, I mean, you kind of hit the nail on the head. The intro, the beginning of this ordinance, the beginning of this process needs some tweaking, absolutely.
Yeah.
And what that looks like, I would be interested in your guys' input, because, you know, we've started with at least get a shared dialogue with planning and council, but, you know, how that can further be pulled, would certainly be interested.
So you have another slide here, Jim, where you list past agreements. What's missing from this for me is dates. I have no idea what the dates were. So that would just give me a sense of, you know, how old they are. You know, we can go and look at them. Did they work out the way they were supposed to work out? I just don't know. So if you could add the dates, that would be really helpful.
Absolutely.
The other thing that's missing from the conversation today is the developer's perspective. I mean, it's supposed to be a good process for the town. It's supposed to be a good process, you know, through the town council, through the planning board for approval, and through the staff group. Is it working for developers? Is there anybody here on the list that's done a regulatory agreement with us that would be willing to come in and share their experience? I would love to hear from them. It's got to be good for them, too. Otherwise, it's a waste of their time to go through all this process. I think it's really important that we get that perspective. So, Steve or Jim, if you know anybody who'd be willing to come in and share their experience with us, I'd be very interested in hearing from them.
It's a great thought. Thank you. Yeah.
And then in reviewing the materials that, Jim, you sent to us 5 examples of regulatory agreements. Thank you for sending that, because actually, when you read the regulation, the ordinance itself, it just didn't translate well into the actual documents themselves. And there were some really striking things when I read that, the existing regulatory agreements. Some of them were better than others. The lack of specificity in the performance criteria is something that was really striking to me. So these public benefits, it's not specific enough. It'll say something like improve stormwater management. What does that mean? Maybe there isn't any on the site right now, but that's a measurable item. So that's just one example. When you look at the performance criteria for what they're delivering to the town, there has to be a data point there, or something that's very easily measurable, so that you can go in after the fact and say, yeah, they really did that. So for example, they're going to use red brick. Well, you can figure that one out. You can go see the red brick on the building. But with respect to improved landscaping, well, what does that mean? Does that mean 20 trees? Does that mean turf grass? Those are 2 different things, you know, but that's landscaping, you know. So I would just say more specificity is needed. And perhaps, this is just an idea, of course, you could come up with a list of examples of the criteria that you could use for different things that you could just pull from when you're preparing an agreement like this. That's just one thing. Something else that was kind of glaring when I looked at this is there isn't a performance bond. So it's pretty typical that I've seen in other jurisdictions, when you enter into an agreement like this, that the developer puts up a performance bond. And it's of course, there's a formula, a mathematical formula to figure out how much that is, but you enter into the regulatory agreement, and they put up a performance bond that is not released back to the developer until all of the criteria are satisfied within a certain period of time after the construction is completed. And my comment is not intended to say to developers, we need more money from you. That's not the point. The point has to do with they need to deliver, and we're agreeing to enter into this agreement with them. We need them to show that they're really going to deliver. And if they don't deliver, we need something that we can draw from to fix whatever that problem is. And maybe it's something really dramatic, like the sewer pipe breaks or something. And maybe it's something that's not as dramatic, where maybe all the trees died because we had a drought, right? So, but we still need to have all of that replaced, right? And a performance bond is a way to do that. The other thing that was missing here was conservation bond. Every project needs to improve environmental conditions on the site, whether it's stormwater management, landscaping, shade, solar on the roof, those sorts of things. A conservation bond is an important opportunity to make sure those items are completed separate from the regular performance bond. So that's something also that we probably should consider with these regulatory agreements. And then with regard to mitigations, Steve, you talked a little bit about the list of mitigations that you all are seeking. There are standard practices for certain environmental mitigations that are different than other types of mitigations, I would say. So for example, open space or conservation as a mitigation, let's just say somebody's going to buy a piece of land and then they're going to transfer the ownership to the town. There's a like-for-like comparison in the type of land that's going to be conserved, and whether it's like-for-like or it has to be greater than the value of the land that they're going to be building on. That's a really important consideration when you're talking about quantifying, the environmental mitigation. I was really happy to hear you talk about the design guidelines, because I think that's a really, really important feature, and I know some of the public comments that I gave at those joint meetings with the Historical Commission were really, it's really important to be able to say to these developers, or redevelopers, if you will, exactly what it is that you expect to see. Because I had the same challenge that you expressed, which is, well what are the historic features that are being preserved? What does it mean? There should be a menu of items to draw from. That's just my opinion. Maybe the menu is 25 items and they only need to pick 5 or something like that. I think we need to be more specific in what it is we're asking them to do. So anyway, those are some of the comments that I have today. I'm sure I'm going to have more in a few minutes. But those are some things to think about. These are some things that I've seen. And while these developer agreements are only for these these regulatory agreements are only in these specific circumstances, when I was living in Virginia, every development project had these regulations associated with it, every single one. And we would see 20 to 25 development projects at each town council meeting come through for review. And they all had agreements like this. So there was a public benefit for all of those projects coming forward. And it may be size difference with respect to the size of the project. Maybe if it's just a 1/4 acre lot that's going to be redeveloped, or maybe it's a 3 acre lot, I'm just making that up. Maybe the larger the project, that makes it qualify more for a regulatory agreement, because the process is supposed to be easier for us and for them, right? Anyway, those are just a few comments. Yeah, I hope that's helpful.
Thank you, Kathy. We go to Mr. Alsman and then to Jeff.
Yeah, I'm perhaps will sound like I have a totally different viewpoint, and I guess I do. It seems to me that there is an overall benefit to the community of getting good quality development that is well designed and meets the use needs of the community. And it's very important to get the kind of developers in who can do that. And so if I was going to add a burden to this, I would say, okay, how do we really let more good developers know what's going on? And there are good developers, and there are other people who develop things. So that's just sort of a general sense. As I read through everything related to regulatory agreements, I found it extremely confusing. There is nothing simply, is our city attorney here? I mean, there are so many whereases and stuff like that it scares the bejabbers out of me, and I think out of anybody who says, oh, this is how we do this, and go, oh my God. And let's hire 3 attorneys to work on this, and we can't get that architect because we're paying all these attorneys or something. And that's just sort of a general impression I think major developers and folks will look at. So there needs to be a fairly simple entry into the process. The ability to have a casual conversation with Jim, with maybe members of the council, I don't know, but says, where you can probably clear a lot of the concerns out of the way. When it gets to public benefit, I worked in a community called East Palo Alto back in California, and it was basically a multiracial component. Wasn't part of Palo Alto. It was actually in a different county. And they tried to squeeze everybody who came into town, and they got nothing. So how you do this so that there's a balance between, oh my God, and oh my goodness. It's the kind of thing to me that says maybe it's just a matter of having a public relations person take a look at, presenting how this is coming forward and say, hey, this is a really positive thing. We've got great ideas for this community, for this whole section of our town. And how do we promote it as something that is really going to be valuable for the developer, for the community, for the citizens in town, and you make everybody feel good about it. The other aspect, which is something I think is, all of this is sort of reactive. I had no idea how much had been done in terms of the zoning for this area. I think you've got so many great tools here, and it just doesn't seem to me that you've built upon that in terms of public relations and with the community or with others. And it would be good if I had a brief conversation with Jim, and I said, what if you took, we got 23 of these things now, and you sort of said, okay, we've got all these pins in the map. Let's take a couple of examples of what's between the 2 pins and say, what could we do here? How would we envision this area happening? So it was more proactive and said, hey, we sort of see this happening. We'd really like to see that happen. And something like that. And, you're going to have issues with property owners who are going to say, what the hell are they trying to do, take my land? That's not the intent. The intent is just an initial sense of what could happen here. So that's sort of my general reaction. Simplify things, make it easier for people to understand what it is you really want. Our attorneys back, fewer whereases, and anyway, that would be my premise, because I think you've got really strong tools here, and they're all going to. It's taken time, and it's going to take more time in order to flesh them out, to make incremental changes along the way. That's my speech for today. Sorry.
Could I just mention two things, if you don't mind? You nailed it with the balance. It's so critical to strike a balance and collaborate with an applicant to, if it's a beautiful project and it's going to provide that public benefit, you don't want to ask too much, because it's a two-way street and they could just walk away.
I
So-
don't know what they bring in initially. I mean, if they bring in sketches or if it's just, I just want to talk.
Well, that was the second thing that I wanted to mention is this man right here does a phenomenal job of that initial collaboration. And that collaboration is not dealing with things that the planning board would deal with in the negotiation. That initial collaboration is simply, are you meeting the requirements and are you on the right legal path here? You know what I mean? Just kind of guiding and shepherding the applicant so that when it does get to a point where it's ready for planning and town council to look at it, it's actually something that is logical, makes sense.
Yeah, there are so many ways of, once everybody sort of gets going in the right direction and gets committed to something, that a lot of the other things that are the bulk of what I read as being the agreement having to do with the public, a lot of the public works things that are, down to the detail, they just come along. They get sucked up in the draft as a part of what you need to do in order to make the project happen.
Yeah.
Thank you, Ken. Jeff?
Thank you, Mr. Chairman. It's funny because, well, ironic, I should say, because my first time I worked with Felicia was form-based code. And her and I spoke about a lot of things that both of you have spoken about. But one thing that Felicia did show me and teach me was that regulatory agreements, design guidelines mean absolutely nothing without enforcement. So we get back to that again. So one thing that I feel we have to do is, at least something coming out, one of the things coming out of this committee is that we have to give planning, building, the resources to enforce these guidelines and regulations. Because Felicia gave me 2 or 3 different projects. I think one was CVS, one was the hotel, where they didn't keep up with their end of the bargain. And so this is all great to talk about. It's all great to have on paper. But if we don't have teeth behind it, then we're just spinning our wheels. So that's all I wanted to say.
Thank you, Councilor Mendes. Councilor Crowe?
Thank you, Bob. First, I want to say I really appreciate both what you guys have said today. And Steve, I really am interested in getting to know what you're doing better and that kind of thing. And I really like what you said about having discussions prior to a whole proposal being put forward and having the public and the town council have a little idea before that. It's sort of like, I'd like to see the paper headline say that this developer is proposing this coming up in the future versus has proposed. And that would be, because a lot of the things I've seen in the past in this town, not all, but some, is that it seems like they're fully fledged out when they come to the public for the very first time. And that's one thing that really gets people's back up. And as you said, there's times where you bring it to the council and it's like, forget it right away. And I think we can save us all a lot of problems with what you said. And I think we work on that. We placate a lot of what's happening with public's drawback, because they know what's coming and they see what their benefit is and they see that we need this in our town. Okay, it's a question of then all of a sudden just versus all of a sudden just plopping it down. And I really appreciate what Kathy has said. This performance bond idea was probably one of the best I've heard in a long time. And it's obviously something you've done, other places have done for a long time. And it hits Jeff's comments also too. So that this is money they put up forward, but they get back as long as they do what they say they're going to do. And it's a way that, once it's all, everything's checked off, you send it back their check. And I think that's wonderful, because I understand we've had a problem with performance in the past about people saying they're going to do something and never ends up being done. So I really appreciate the positive attitudes we have here about getting communication earlier. I think that's really what in my past and my village's past and a bunch of other things, all of a sudden you get a fully formed thing, it's dumped on you saying, one read and then the next read is going down. That can't happen anymore, and it really doesn't help anybody. It doesn't help the developer, it doesn't help the planning board, doesn't help us. And I think we can mitigate that very easily by some of the things you suggested tonight. So I appreciate both you guys doing that. And I feel very positive about this going forward.
Thank you.
Yeah, thank you, everybody, for your great comments. And I just want to piggyback on the performance bond aspect. We do have a lot of experience with that. It is a tool that we can use. You're right, it's omitted in all these regulatory agreements, and that's something that I wanted to highlight there. So that's great. Kathy beat me to it again. But it is something we certainly do. We actually have a system now in place. I've been working recently with our town engineer. They go do inspections. They report back. Developers can draw down from that performance bond if they've achieved certain things. So that's certainly something we can absolutely implement in regulatory agreements moving forward if one comes about. And also I will mention in the form-based code, because of President Penn, there is a performance bond for landscaping requirements, at least already built into the zoning.
Yeah, nice.
Go ahead, John.
I just have one more thing, Bob. Also, the design guidelines, I'd like to see what those are. I understand they're not completely finished yet.
Almost there, yeah.
I think a thematic presentation is what people want to see when they come down to one section of town. I think you get some buildings that look one way versus the other, and not saying all the same, but I think that's important, is that we have a general idea of what we want it to look like, and it all goes together in a certain way. And I think that's important. I haven't kept up on what has been worked on before, but I think that's probably where you've been going, and I think that's important, and I'd like to see that. Thanks.
Well said, and I will just state for the record that that will be a publicly noticed meeting, that joint meeting. That draft will be added to the town website in multiple areas and will be available for review. So,
Great. Thank you.
Mr. Chair, I just want to say that when Jim was going over the map and saying, yes, the original growth incentive zone was originally where the regulatory agreements were, but since then, we added some here, here, and here. And when that happened in this town, my heart sank. Because the whole point of a regulatory agreement and a growth incentive zone is to put the growth, that's why it's the growth incentive zone, where you have the infrastructure, and to keep it away from where you don't. It's very simple. And that's mentioned in the Cape Cod Commission rules. And since this is a product of the Cape Cod Commission, it makes sense that it would line up with that. So the first expansion of the regulatory agreement zone, I believe, was 35 Scudder. I could be wrong, but I think so. And that's because, now this is my theory, okay? I'm just kind of a student of history here. That's because the developer at the time had come before the planning board twice and asked for his land to be included in the growth incentive zone. Now that land is marshy, swampy land that has 5 foot of fill on it, okay? It's a sensitive environment, 600 viable trees, hundreds of species of whatever, and it's in downtown Hyannis. Hyannis doesn't have a whole bunch of environmental stuff like that. So twice, the owner of the property came before the planning board, and twice the planning board listened, asked questions, deliberated, and denied his request to be part of the growth incentive zone. 2-3 years later, all said and done, he hires a new attorney. All of a sudden, they come up with a regulatory agreement zone. Well, you can't do that if you're not in the growth incentive zone. But they did, because he wanted to develop the property. That's shameful to me. You're giving away the whole point of why you need a regulatory agreement in a growth incentive zone, because you're blowing all the all the parameters off of zoning. It's the only reason you need one. Otherwise, it's a development agreement, and it's not going to cost you a whole bunch of money, right? But when you start asking for waivers on stuff, buck up. That's all I can say, because we're not going to give it away for free. And yes, we are the only town on Cape Cod. I think Orleans now has a growth incentive zone, do they not? In their downtown?
There is one new growth incentive, or more recent growth incentive zone.
Yeah. But when we did that, we just made everything free. And it's shameful that we didn't say no. Because then we got what we got, and then we got what we didn't get, and we got all that. You got how many hundreds of hours of this, that, and whatever else it is. I don't know. But anyway, so I'm just somebody who's a person of integrity when it comes to land use and zoning. And I think that if something is put in for a reason, meaning build here because that's where your infrastructure is, keep it away from all of this around here because that's too environmentally sensitive. That's the whole point of this area and what we're doing. And people forget that. So then you start giving it away. What's the point? It just dilutes everything. So we need to go back and look at that. Whether we can change that now, I have no idea. I don't know what the rules are on any of that stuff. I just like things to be real and true to form. Thank you.
Thank you. The beauty of being the chair, I guess, and I know I'll live to regret. Oh, I'm sorry.
I don't, excuse me, I don't know the history, but why was Centerville Main Street added as a regulatory agreement?
I think I know why, but I'll let Jim answer.
Well, I have the town council order here. I don't know the history, but I'll share the summary that was provided to town council to everyone and put it obviously on public. But Steve, if you have history there.
What year was that done? Do you know?
This was in 2009.
I'm curious too, as a Centerville resident.
Oh, then my theory's wrong. I thought it had something to do with the cell antenna that went into the church. But I think that was a special permit, right?
I'm happy to read the rationale if you'd like. Yeah.
Yeah, great.
So,
Can you describe more specifically what is the actual area? Is it all of Centerville Main Street or a portion?
let's see.
I don't have the map up in front of me.
Sorry. Yeah. Yeah, it's probably going to be too zoomed out for everyone there. I can get the actual parcels for everyone as well. But the rationale here is the regulations respond to and support the purpose of the district of critical planning concern, which included protecting village cultural, historic, and architectural character, which is accomplished through use regulations, dimensional regulations, and design guidelines to locally owned businesses, economic resource, and supported through allowed by right uses and formula business prohibition. The inclusion of the regulatory agreement process will allow the town and the business uses to work together to address additional needs as they may arise.
Maybe it's just me, but it almost sounds counterintuitive if you want to preserve it, but we're doing a regulatory agreement to develop. So anyways, thanks for the reading of it.
So I guess the question would be if there is areas within Centerville or the Twin Brooks area is are we able to undo those things because it does seem kind of counterintuitive or nonsensical? Is that something?
I think we should find what is the process for changing the map, and I think that should be, yeah.
I'm sorry. They said it was to preserve, correct? Come on, you're supposed to remember this.
Well, the last line there is the inclusion of the regulatory agreement process will allow the town and business uses to work together to address additional needs as they may arise. So much like I mentioned early on, if there's something of benefit to the community, you may be able to provide this that doesn't meet the zoning requirements. So that's what the rationale was back in 2009. Can't change it, but we certainly can discuss changing,
Well,
looking at the process for changing maps.
When was, when was the old softball field on the left-hand side redone and converted to that playground? Do you know that?
I don't know.
There's the old, I don't know what the building was. Felicia, what's the white building across from the country store?
Yeah.
The recreation center. When was, if, I bet you it probably had something to do with that conversion to that playground.
I don't think so, because it's town-owned, and they wouldn't need that.
Yeah, good point.
Then I wonder why.
So Chair Schulte, will you be able to ask how we go about amending the process, as Steve has recommended?
Amending the map,
Amending the map.
Good to know that, yeah.
if necessary. I mean, we don't know.
Yeah, no,
yeah,
no, I
just to
mean,
make-
it's
again,
just
it may
kind
be
of
something to-
curious, that's all.
Yeah, it's not saying anyone would do
recommend.
anything, it's just curious.
Yeah.
I know that the District of Critical Planning Concern, DCPC, came in because the one guy near Short Beach Road, you know, he started to build up that huge thing, and everybody was freaking out about it and saying, oh my God, how come he's doing this? You know, this is out of proportion, this isn't right, this isn't in character, blah, blah, blah. So they did this District of Critical Planning Concern, saying, so that nobody else in that whole neighborhood could do that. Okay, they couldn't stop him because they'd already given him the building permit, okay? I don't know why, but they did, all right? So I'm wondering if the reg agreement came out of the DCPC somehow. I don't know. It's kind of far away from Main Street, but you never know.
Okay. Well, I started to say, I know I'll live to regret saying this, but as the chair, it's kind of nice, everybody's covered most of the things on my to-do list here to talk. But, just a,
I just have one final comment on the regulatory, I said I was going to have more, right? So there's one other glaring item that's missing from these agreements, the sample agreements that you sent out, is a reporting back feature. So the developers, they're signing all these agreements. We spent, I don't know, a year or something coming up with all this, but they never come back to the town council or to the planning board and say, well, this is what we did. There's no formal reporting out here. Seems kind of odd.
Yeah, for a normal development, well, not regulatory, maybe not regulatory agreements, but say subdivisions or special permits, there's requirements of as-built plans that are provided back to the department, which is provided back to the board. But you're right, no presentation per se.
So Councilor Mendez talks a lot about enforcement, and others have mentioned that also, very important to do. How do we know they did any of this stuff? Formally, I'm talking about formally.
But before they have an occupancy permit, does not the property get inspected?
Oh, yeah, administratively, we are through inspectional services, through DPW, through planning, all of that gets inspected. But to Kathy's point, in terms of a presentation to a public board. that doesn't-
Accountability.
Right.
Yeah, that's what I'm getting at, exactly, accountability. And did they really do all those public benefits? Are we getting all of that? I don't have an answer to that.
Well, it's a great point, and it's something that I've thought about as well. I mean, we added something to our agenda that's just staff updates that Jim talks about, kind of what's going on with the planning department. But I also asked if it was possible to hear about when an occupancy permit was granted by the building department, because, that would give us an opportunity as board members to drive by, take a look at it, see what's going on. At CPC, I just went to a site visit yesterday at Sturgis Library because we funded a heating system that they did for their vault. So I got to get in and check out the vault and look at the history, and that was pretty neat. So, obviously we have to avoid open meeting violations. We can't all go together and do a site visit, but we've done group site visits with, a few members to check and make sure things that have been done. The Walgreens, I famously negotiated a lattice work on the front, and it's missing. And
No kidding, I'm shocked.
so, again, I said I wasn't going to bring that up, but I decided to bring it up. And the only reason I brought it up is because I agree with you 100%.
It's a prime example. Good for you.
Yes, because I know exactly what you're talking about, where it is frustrating, especially design elements, landscaping. Yes, we need to know that it was done and done right. And one of the best ways to do that is for town councilors and board members to actually get on site and look at everything, so.
Okay, thank you. Just a few comments I've got. No particular order, looking through the list of the material benefits, I think 9 was kind of an all-inclusive, but I'm just curious, and I'm not looking for an answer now, but just something for us all to think about, based on both of your experience, Jim and Steve, is there anything from your perspective that's missing from there? I mean, like I said, number 9's a catch-all, but are there any other things that we might want to identify that could be, provided in more specificity? To one of Ken's questions, I've been thinking about this too. It's kind of from what I've gained from my experience in the community and watching, development typically happens at the initiative of the developer. One of my questions was going to be, it seems like these reg agreements are initiated by the developer. Have we ever given any thought to flipping this, identifying areas that we may want to attract a developer? That goes along with, getting the right developer, someone that's going to come to town, someone who has a history, rather than waiting for them to come to us. If that's the objective here, maybe we need to be thinking about doing that. I think the performance bond, great idea. I think another question that I've had in reading through some of the summaries, it was very unclear to me exactly how time limits on these reg agreements work. I wasn't sure. So it's a 10-year agreement. Does that mean at the end of 10 years, if they promise not to, build out to the lot line, at the end of the 10th year, can they go and do whatever they want, or use it for parking? Does it mean they have 3 years to start construction? If they don't start in 3 years, the whole thing's out the window. I don't think there's any real clarity in my mind as to how the time limits work and how developers, and the town, look at that. So I think that would be something I'd like to learn a little bit more about. And again, the other question, I was thinking about that too, and it's come up, and it would be very helpful maybe to get some insights, maybe from legal and from the planning board as well as the planning department. If our recommendation is to the town council, you may want to rethink. Maybe we don't want to have Centerville. Maybe we don't want to have 35 Scudder as part of the development areas. What's the process about changing that? And then finally, as far as the uniform guidelines, you mentioned, Steve, that those are going to be posted. What's the process for the approval of those? Is that something that will come to the town council, or do you guys just decide this is the Main Street Historic has approved it, and we've approved it, and it's posted, and it's a done deal? Who actually approves that?
This is one of the only things that we don't need town council to sign off on. Right?
Oh, and because the reason for that is their guidelines. If it rose to an ordinance, that 100% would have to do a typical zoning change process where it go to planning board, then it goes to town council. In the ordinance of the Hyannis Main Street Waterfront Historic District, it says that the commission can update their guidelines from time to time. And so, but through a public hearing process, and so they have to hold a public hearing as they did last time, and allow for public comment. So because it's guidelines, that's why that level is such. That doesn't mean they can't come to town council if the commission or the council wants them to. They could make that ask to the commission, certainly.
We've actually talked about that. We want to, if we do pass a unified guideline, we want to present to town council to let the council know what we've done. But it's also a public hearing, and councilors should also attend, and anyone should attend, and offer remarks.
Okay. Yeah. One other thing, two other things. One, I think I've heard this from everybody. It started off with Jim commenting about, the desire to get the process started earlier, getting more people involved. Steve, you said that. Kathy, you've made comments. Given we're seeing less of these reg agreements, particularly in light of the form-based code, not to put more work on the counselors who are here, but I do like the idea of maybe when the process starts, that there is an initial informative presentation done at the council so the public hears, hey, somebody's thinking about developing whatever, 10 stories on the harbor, or, 500 units in Independence Park, yeah, so the public knows about it. Whether it's accurate or not, the reality is that, a lot of people are not aware of it, don't see it until it's coming pretty much fully baked, and that's why there's so much opposition. If the public was aware of this much earlier in the process, and if we're hearing these things start much earlier, so there should be an ability to inform the public of that. So, and then my final comment, and I know it's 5:15, and I know everybody wants to get going here. Mr. Florence has been kind enough to be here today. We had the next item of enforcement, but I think enforcement's an issue. Maybe we could just ask you to touch a little bit on that, particularly as it pertains to, regulatory agreements, because I think that's come up numerous times, as how that happens and stuff. And again, I want to be conscious of comments that, some of the committee members have made, that you can only do so much with what you're told to do, and given the money and the ability to enforce that. So before we go to that, then, Kathy, did you have another question? Okay. Any other thoughts? Otherwise, we'll. Sure, John.
I think what you brought up earlier, with, Bob, with Felicia and everything else, is that this proactive going to property owners and saying, here's what we think would be, prior to them saying, some developer coming to them, is that we get on top of it and say, this is sort of what we'd like to see in our town, and change the philosophy of reacting to proacting, and see if we can say, hey, this would be a great place for this, and this would be a great spot for whatever building, and going to those owners first and saying, this is what we like to see here. I think we'd be good, and see where we can go from there. So I really like that idea, and that's been discussed a number of times. And it seems like we're always just, somebody comes up with a project, and then we're stuck with it, okay? And versus having been far ahead of it and saying, this is what our village and our Main Street needs.
May I just real quick respond to that?
Sure.
Absolutely. And specific properties, I 100% agree. I would love to go door to door and to talk to everybody, honestly. But I think one of the aspects of the downtown Hyannis zoning attempt, at least, was to start formulating that conversation to say, we want these buildings to have character, such as the design guidelines. We want these buildings to be closer to the street to add pedestrian amenity, or to that pedestrian feel. We want parking hidden in the back. So we start to form what we want to see there. The design guidelines hopefully will supplement that. But that's not to say that it can't be taken a step further. So absolutely room for improvement there. And yeah, we can certainly start thinking about how we can have dialogue with property owners too, to educate them, and then see what we can do to see some investment in that area as well.
Thank you. All right. Mr. Florence, you have the floor.
Mr. Chairman, committee members, again, thank you. Brian Florence, Building Commissioner. So with respect to regulatory agreements, the Building Commissioner is not a party to that. The parties to the regulatory agreements are the Cape Cod Commission or Cape Cod Commission in the Town of Barnstable. This is in Section 168.4. The Cape Cod Commission in the Town of Barnstable and with the state agencies, or the Town of Barnstable, or the Town of Barnstable and state agency, or agencies. That's how it reads. So I'm not a party to that. And my role as the zoning enforcement officer is statutory. It's under Mass General Law 40A. This isn't part of that. This is not a zoning document. So I don't have a party. I'm not a party to the agreement. I'm not the enforcement officer for it. If you look at the end of it, end of 168, it talks about who the enforcement, where the enforcement comes from, and it comes from a court of competent jurisdiction. You need to be a lawyer to bring it into the court of competent jurisdiction. So, all right.
Yeah.
Okay. So I
get a question.
Sure.
Can we rewrite that?
Yeah, I guess that's a question. I mean, so the answer really is, essentially, there's no one enforcing the reg agreements unless we want to go hire an attorney and go to the Cape Cod Commission, and I'm sure they've got bigger fish to fry.
This is contract law. I would be useless arguing in a court on this. I would not be any help at all. So it's a contract that should be done under contract law, and it should be done with attorneys.
Seeing we're doing home rule, in designing stuff as long as we're not conflicting with the state. My guess is we could insert a process, if we so choose, okay, that allows a third set of eyes who has nothing to do with the whole negotiations, which is a perfect situation in my book, to go in and say, this is what I saw at the end, this is this is that, this is this, because we could give him a checklist based on a reg agreement. And if he comes back and he says, geez, of these 16 things that you said to check out, I only see 3 of them are done. He's servicing us. It's not challenging the courts in any way. The question is, what do we do about it if that's true at the end? Now what do you do? Right? So, I don't know, maybe we should have a conversation.
We do provide that service.
Do you think we should?
Provide that. We've been asked before to go out and look and see if all of the items on the regulatory, and planning and development asked us to do that, if all of the items were done on that, on the from the agreement. So we go out and look, but we don't enforce it. We don't take the guy to court or the person to court. We don't do the enforcement part of it. So, but yeah, we already do that, and we're happy to continue.
You do that.
If you want to formalize it, I'm sure you could put in there that, it gets an inspection, but we do that anyway.
Yeah.
Yeah.
Can I ask, just for example, Mr. Robichaud brought up the Walgreens project, did someone go out from the building commission and review the Walgreens and notify them that the lattice hasn't been done? I mean, you say it's been checked, but does it get checked all the time, only when you're asked to check? What happens when you find something that's not been met? I understand you can't enforce it, but what do you do with that information?
What we don't do is police. We don't have the staff to go out and police after something's been done, after a certificate of occupancy's been issued. The lattice that's missing is missing after. And so when we don't send somebody out 1, 2, 3 years into the future to make sure that they're complying with these things. We just don't have the staff for that.
No, I understand that. I guess I'm just saying if there were 16 things in the lattice, maybe the lattice was up and then it came down. But I'm saying, do you ever come across a situation where your group is asked to go out, understand, not enforce it, but just to say, here are the 16 things, and you found that only 12 of them were done? What do you do with that information?
We were asked to go out. The last time it happened, I did it, and it was on a piece of property on Winter Street. And we were asked to go out and look at the checklist and see if it was done. We were asked to do that by the director of planning and development. I provide that information. I'm not sure where it went from there, but I did provide that information.
To the person who asked for it.
Yes.
Yeah.
Yep.
I just wanted to say just 3 things. First of all, yeah, definitely an area that needs to be improved. 2, Jim, this isn't something that can be done as a condition, right? You can't condition that all items included herein will be enforced through the building department.
Right. I think Brian will tell you that there's
really
some consequences to that. It might not be enforceable at the end of the day. Okay. What I will add, though, is what we had just talked about earlier about performance bonds. Mm-hmm. So that is something that we can hold on to for a period of time. I will say, though, just as a caveat to that, something like lattice, so the process is right now, though we haven't had to really do it since I've been here, but in other projects, we will ask the building commissioner to look at the site and building structures. We'll ask DPW engineer to go look at the infrastructure, and then I will go out as well, or someone from the department will go out and review some of those other amenities that maybe it's not a building code thing, or it's not drainage, but maybe it's like entry shrubs or something like that we were very cognizant that the planning board or town council was adamant about. We make sure those are there as well. I will say, if there's a performance bond, let's say it's a $500,000 performance bond, and they've done everything for the building, they've done everything for DPW, that lattice is only valued at probably, $50? So the developer.
Come on, Jim.
Sorry. A higher quality lattice, I don't know what that runs. But whatever that runs, that's what that drawdown would likely be. So that would be what would be left. And it depends on how important that specific aspect is to the developer. So again, we always like to, when it's subdivision time, we always try and hold a lot back because that lot's valuable. And so they're not going to leave a lot behind. So, we can give that some thought about how performance bonds could play a critical role in enforcement, perhaps, to supplement the building commissioner and the town engineer when we're doing this.
One way around that is you insert a minimum, if they're not met. I mean, maybe we have to think about recommending the creation of a performance bond officer or something that goes out. If there's 17 things in their reg agreement, they've got to meet them all. If I was a developer and I was, going to shortchange putting up the lattice work, and I knew I was going to get $100,000 in my performance bond, I'd go out there and do it myself on the weekend. So you got to put some teeth into these things. So
Good development.
Yeah, and that was my last item with the performance bond. When I think about bonds related to subdivisions, it's like, okay, if the drainage isn't finished, that bond is used to go finish that drainage. Does that mean you can use a performance bond to go buy your own lattice and screw it to someone else's building? I don't know. I don't think so, but that's where my mind goes. So that's all. Thank you.
Mr. Chairman, I just
Just
want to make sure that I've answered all your questions.
I think so, unless anybody else has anything for him? Okay. We'll go.
Yeah, you have a question?
We'll go with.
No, I don't have a question. Oh, okay.
Okay.
I was just wondering if it's something, since we're at home rule, if it's something we can have legal look into, because there may be some kind of cutaway in the law that we're not aware of, where we can form our own enforcement officer, enforcement bureau, under one of these departments. Because it's been an ongoing issue, I mean, long before any of us. So it's something that we should really look into to see, if there's something we can kind of do and start our own kind of enforcement, because that's the only way it's going to truly get done.
Councilor Crowe.
Really quick, the performance bond is something they want back. It's their money, okay? Money earns interest, okay? If they don't finish it, we can hold that money for as long as they do finish it. I assume that the onus should be on them to get their money back as soon as possible. So therefore, they would they would be calling your offices and saying, hey, we want you to come out and check the checklist. It seems very simple to me. Okay, we can hold that money and we can earn some good change.
Absolutely. And yes, they do call often. And to Mr. Schulte's point, a minimum might make a world of sense because, to my point, in like a subdivision, for instance, yes, they're gonna do as quick as possible, get all the big dollar items done so they can get the most drawdown immediately, and they'll leave the $100 worth of whatever left over and just not bother with it because it's going to take, their crew might be already onto another location. So they've drawn down everything other than just a small amount of money. That small amount of money is not as valuable to them, and they move on. Sorry, go ahead. You look like.
Why do we let them draw it down in any degree or to a partial degree at all until they finish everything? Okay, that would be the thing. Is like they draw on this item, this item, but until you finish all the items, you shouldn't be getting that bond back.
Right.
Okay, so that's what I'm saying. Is that what you're saying? Minimum. It's like, sorry, you've got to finish everything before we give your money back. And if they take down to a small amount, I can see them walking away.
Yeah.
But if you don't take it down at every little step, then they're going to be wanting that money.
And so putting that in writing would help us administer it that way. If it's not in writing, it's going to be hard to hold, a $500,000 bond when they only owe $100 left or something to that effect. So if it's in writing, absolutely, would love that.
Kathy?
Just as a practical, real-world example, as the president of my homeowners association, we held the performance bond because they didn't install a handrail. They didn't install the handrail. And it was a very steep set of steps, and we held them. We put their feet to the fire, and they did not get their performance bond back until they installed that handrail. It would have been more expensive. It would have cost them probably $3,000 or $4,000 to redo their site plan, to remove the handrail from the site plan in order to eliminate that. And it was cheaper for them, obviously, to install the handrail. Maybe it was just $100, but it's about the details. The devil is in the details, as they say. And this is a really great example of you hold their feet to the fire and they need to do what they promised, and that's the best way to do it. and then you cut the check after I got it done.
And that's a great example. The HOAs play a big role in this towards the end of it as well. We're actually actively working with at least one HOA out in Barnstable Village area about trying to get that accomplished as a together.
Great, thank you. Any other thoughts or comments? I'll defer to Attorney Connolly. I want to make sure that I don't avoid any open meeting law issues. If I were to ask the individual members to email me with their thoughts, what I'd like to do is let me ask, how do we do this? What I'd like to do is come back to Jim and Steve with kind of a summary of all the various things, and I don't know the best way to put that together. I've been taking notes, but I think others, how do we facilitate that for our next meeting, maybe just to say, here's a summary of the key issues, so they can give some thought to at the next meeting. So how would we do that?
Yeah, in order to comply with the open meeting law, Mr. Chairman,
mic on, please.
email each other.
Oh,
Sorry.
okay.
Can you hear me now? You cannot, committee members cannot email each other. There's
Even
actually.
just one to another? Okay.
No, it's considered a serial communication. Nigro
Okay.
versus Connolly, I believe my last name was involved in the case. I think it was
Okay.
the city of Boston. Yeah, Felicia emails, you each email each other. It's like you're communicating outside of a meeting, and
Yep.
it has to be done in a meeting. However, you can give your comments to Cindy,
Okay. So,
and then they have to be discussed at the next meeting. You can't have a back and forth discussion through her. You can share information, but that's it. You can't have a discussion about it. And information, I don't mean your comments. You can't share your comments with each other.
okay, so let me ask you what I'm envisioning. If I ask the members of the committee to email, the issues like Kathy may have mentioned, performance bonds or whatever, to Cynthia to say, these were the key issues I had after this meeting, and then Cynthia was to send those to me, I could put them together in a single list to send to Steve, or to Jim or Steve, to say, this is just a summary of the key issues?
I think it would be better if everybody just sends their information to Cindy, and then you could discuss it at the next meeting. Or she could send it directly to whoever you wanted to get it.
Okay, okay.
But you have to avoid even the appearance of communicating amongst yourselves outside of a posted public meeting.
Okay. Okay, so I'll ask Jim and Steve, we've talked about a lot of different things here. I don't know if you guys have been able to take notes and things, or you're trying to save you the trouble from going back and watching the video. If we were to say there were 12 key things, if each of us send to Cynthia our thoughts, then she would forward them to Jim and Steve, so that, next meeting, because there may be a few things that we would discuss, we'll have that list to them.
I guess the word thoughts is concerning me, because taking notes
Their
on what
list
was
of issues.
discussed or a list
I'm
of
sorry,
things.
list of
Yeah,
issues.
but you can't write about your thoughts and share them
No.
after the meeting. You can have a list of things we discussed, but I mean, that's something that the note taker is going to be writing down anyway. So
Okay.
what would be the purpose in having to do that before the next meeting?
It was just so that Jim and/or Steve, had a record of the key items that we discussed, not thoughts on them.
In the notes.
Okay, all right.
My preference
Okay.
really to avoid an open meeting law violation, and minutes are part of what's governed by the open meeting law.
Okay.
Wait till the minutes are done. Everybody review them like we typically do. Add
Okay.
anything that you think might be missing, and then send them
And then we'll
to
do- Okay,
Jim and Steve and whoever else.
okay. That's
Hi.
fine.
Could Steve and Jim submit questions to us that we answer?
No.
No. No, I mean, well, through Cindy.
No, because you'd be answering your board members, and you have to act as a board.
Okay, all right.
So you can discuss them at the next meeting. When they look at the minutes, they can come up with questions.
Okay, then I guess as a practical matter, I believe we're scheduled to meet next Friday, the 26th, 3 o'clock, same place. Cynthia, we'll look to you to get a draft of the minutes to us. I think, again, realistically, if I can ask people to take a look at those minutes and have any comments they might have, hopefully then we'll all decide that everything, all the items we brought up have been mentioned. Then can we then share them with Jim prior to the reading and approval of them at the next meeting, so he has them in advance of the 26th, or do we need to wait till?
Well, that was your question to me earlier. You really, across the board, need
Yeah.
to wait till the committee itself finalizes the minutes, and then you can share them with others.
Okay. All right, Jim, I hope you can attend next Friday. Steve, you're certainly welcome if you'd like to. And hopefully we'll have minutes that we can approve that will kind of summarize the key points that we've discussed today. So, okay.
Mr. Chair?
And
I just also wanted to mention that I think the IT support staff wanted to know if ad hoc committees could schedule out several meetings ahead and not just do it one week at a time kind of thing. So I don't know if you want to send out a, how you want to do that, but just think about that.
Yep. Actually, that was next on my.
Oh, I'm sorry. I'll be quiet.
No, I was going to say, so well, I guess first want to confirm that we think we all agreed to the 26th, which would be next Friday. I think we also all agree that we'd like to try and meet twice a month anyways. I think Cynthia sent you all a list of dates for August and September that Sarah had provided us that currently has availability, understanding that schedule will change on a daily basis as other things get scheduled. But I was going to ask everyone to please take a look at that. At our next meeting, let's try and identify the 2 dates in August, and if we can, the 2 dates in September that we can schedule so they can get it on their calendar, and IT knows that. Does that all make sense?
it does.
Okay.
And Mr. Chair, if I may now, through you to one of the previous speakers, I have a question to Councilor Crowe.
Absolutely, yeah.
Can you tell me the name of, I believe it's the defendant in the Osterville case, so that I can find that old case? You said it was Seaview Avenue?
It was on Seaview Avenue. The fellow's no longer living there, but I believe it's spelled Spenlinauer. Spenlinauer.
Spenlinauer, okay.
Something close to
So I'll find
that.
it, thank you.
Yeah.
And just one other comment on the schedule of the meeting. Mr. Robichaud mentioned, obviously, as I think all the committees in the council, well, the council has a little bit more sway on when they have their meetings, but the committees, it's always difficult and a challenge to find a time that members of the public, if people are working, then working hours, they can't meet. Someone suggested meeting on the weekends, but then the AV folks aren't there. When we first had our meeting, it seemed like the Friday afternoon worked best for most of the members. I'd love to be able to have it that anybody who wanted to come anytime they wanted, but I think realistically, so I guess when you look at the available dates from Sarah, maybe we can mix it up occasionally. Instead of having a Friday 3 o'clock, maybe we can have it on another day of the week or earlier in the day, just to try and make sure we provide access to people who can't make it on Friday in the afternoon. So I know, and some of our counselors, are working schedules and stuff, so just give some thoughts to that. Yes, Councilor Trickelson.
People could also submit public comment in writing ahead of time if they can't be here for the meeting, so I don't think that should be the thing that limits what works for the schedules of all 9 of us. So.
Okay, yeah, that's true. We ask people to provide written comments ahead of time too, so. And so if you could do that, take a look at that for the next meeting. We'll talk about that next Friday. And I realize, Cynthia, I skipped to the next meeting. Item E was approve the minutes of June 28th. I don't know if there's any formal process other than if everybody's had a chance to read them. Do we have a motion to approve them as written? So moved. Second?
Second.
I believe she circulated the amended ones.
They were
that's
amended
right.
by,
Kate. That's right, Kate, you were going to make some changes? Oh, okay. Well, okay. So then we can, Kate, just to make sure, so we can make a motion to approve them as, that'd be great if you do that again. Thank you. Could you come to the microphone just to make sure? Thank you.
Page 2, paragraph, the paragraph right after Councilor Mendes spoke and then Councilor Levesque had to leave, I just changed that first sentence to read, at the chair's request, Attorney Connolly said that the town is authorized to adopt and enforce more stringent local ordinances, provided they are not less stringent or inconsistent with state statute. She added that some small towns have bylaws along the lines of what Councilor Mendes said, to prohibit, for example, more than one unregistered, in this case, it was unregistered disassembled vehicles per front yard, and the rest is as is.
Thank you. So can we have a motion to approve the minutes as amended, as described by Attorney Connolly? Seconded? All in favor? Thank you. And I'll ask Cynthia. Okay. Okay. I'll ask Cynthia, once those are amended, if you could just email those to everybody as well, that'd be great. So I think then our follow-ups will be, we'll look for the minutes, draft minutes from this meeting, ask you to take a look at those so we can make sure that when we give those to Jim and Steve next meeting, we'll have all the key items that we've talked about, and take a look at the calendar dates so that we can hopefully set up dates for August and maybe even September for the committee. Anybody have any other thoughts? Motion to adjourn? So, second? All in favor? Everybody have a nice weekend.